Last one. All right, good morning, everyone. Are you able to hear me?
Yeah.
All right, this is the state all-purpose calendar in the state court of Fulton County, Georgia. Today is December the 1st. I'm Judge Melanie Williams. Today we'll handle matters such as taking pleas, arraign cases, address bond as necessary. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. When I ask you if you understand your rights, those are the rights I'm referring to. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch this particular proceeding. I do not see Mr. McLean or Ms. Helen on the Zoom conference. Are there any other members of the Public Defender's Office on the screen today? Okay, that's problematic. Or are they at the jail?
Good morning, Judge. He's checking now. Officer Norris is checking in the front lobby to see if the
Okay,
out there.
thank you. I remember last time Mr. McLean was there, so that's fine. We'll be on hold. And I'm hoping that all members have had the opportunity to interview their client. Are there any private attorneys on the line? I don't see any either.
Your Honor, I believe Mr. Lynch was on the line.
He's not here now.
McLean's on his way in.
Okay, McLean is on his way in, Judge.
Judge, Owen Lynch will be on shortly. He just sent an email saying he having problems. I'm gonna resend him the Zoom.
Okay, thank you. So at least we'll be able to take those positions, the ones that belong to Mr. McLean and Mr. Lynch.
Your Honor, who can I send transfer orders to for your review?
Oh, Miss April Champion is in with me today, so please send those to her.
Yes, Your Honor.
Thank you. Good morning.
Hey, Helen, how you doing? Morning. Okay, that's good.
Morning, Judge.
Helen is also here. too.
Okay, good morning, Miss Helen. All right. Have you had the opportunity to interview all of your clients?
I have, Judge.
Wonderful. All right, so we can get started with the position that belongs to Miss Helen.
And just one announcement, I don't know if South Annex is on
Yeah,
yet.
South Annex is actually supposed to go first.
I do have an
Okay.
announcement for those positions.
All right. If you want to give me those announcements, Miss Helen, I don't have the name,
Yes,
I
Judge.
don't know exactly who's there, but I'm
This
sure
is
you'll tell me.
Ms. Britt. That is gonna be a reset for Tuesday. I don't have the calendar date, but we're gonna ask for a reset for Tuesday for Ms. Britt for a social worker visit.
I'm sorry, can you spell the last name?
BRITT, she's position.
Oh, position 7, all right. And you're asking for a reset for next Tuesday?
Yes, Judge, for a social worker visit.
All right. Does the state have any objection to resetting that case to next Tuesday?
Which position, Your Honor?
Position 7, the defense is asking for a reset to next Tuesday in order for a social worker to give her a visit prior to her accepting any pleas or conducting any further matters.
No objection, Your Honor.
All right, so we will reset that case to 12/6 SAP calendar. All right. Any other announcements, Ms. Helen?
No, Your Honor, I'm just ready for the rest of the positions.
All right.
All right, I guess if South Annex is not going first, I'll go ahead and go because they were supposed to go first. Good morning, Judge. We're gonna go ahead and start with position number 21, Mr. McDuffie.
All right, and if South Annex comes on the line after that, we can go with those positions. All right, good morning, Mr. McDuffie. Your case number is 22 CR 007721D. In this case, you're charged with criminal trespass with the offense date of November the 10th of 2022. Do you understand your rights?
Yeah, ma'am, I do.
All right, it's my understanding that this is a negotiated plea. Is that still correct, Ms. Helen?
That is, Judge.
All right, thank you. Is this your case, Ms. Duncan?
Yes, Your Honor, good morning.
Good morning. If you would give me the state's offer as well as very briefly, the basis supporting that offer.
The state's offer for position 21 is going to be, for the case ending in 721D, is 12 months to serve, 42 days. With the balance suspended and stay away from the entire Georgia Tech campus. This defendant currently has a 2-year ban from the Georgia Tech campus. And here, the basis for that recommendation is that the defendant was found on the Georgia Tech campus after receiving a criminal trespass warning on April 2nd, 2022, banning him for 2 years at that time. Nothing further from the state.
All right, and just to clarify, he would not have any additional time to serve the 22 days he's already served, but close the case, Ms. Duncan?
From my understanding, yes, this defendant has served 22 days as of today.
All right, Ms. Helen, was that your understanding of the state's offer? And do you stipulate the factual basis, ID, and venue?
Yes, Judge, that is our understanding of that offer from the state. We do accept it and we do stipulate to the factual basis, venue, and ID.
All right, thank you. Mr. McDuffie, I'm gonna ask you some questions just to make sure this plea is voluntary, all right? Please raise your right hand. I'm gonna place you under oath for the purpose of taking the plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah, ma'am.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with Ms. Helen's representation?
Yes, ma'am.
Did she promise or anyone promise you anything in exchange for taking the plea?
Yes, ma'am.
They did promise you something?
Oh, no, ma'am. Sorry,
Okay.
my mind went somewhere else.
Did anyone force you to take a plea?
No, ma'am.
Okay, and do you understand that by giving up that by taking the plea, you're giving up your right to go to court and present any defenses you may have had to this charge of criminal trespass?
Yeah, ma'am, I understand it.
All right, and you understand that you absolutely cannot go back to Georgia Tech in its entirety, the full campus, but otherwise the time you served in the jail to close your case. You understand that, Mr. McDuffie?
Yeah, ma'am, I understand.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. If there's nothing further from either the state or the defense at this time, that should close out this case.
Thank you, Judge.
All right, best of luck to you, Mr. McDuffie. Don't go back there, all right?
All right, yeah. Thank you.
All right, who do we have next?
Position 25, Mr. Ross.
Hi, good morning, Mr. Ross. Your case number is 21 CR 0002226Y. In this case, you're charged with simple battery family violence with the offense date of July the 29th of 2020. Do you understand it right?
Yes, ma'am.
All right, the announcement I have that this is a non-negotiated plea. Is that correct, Ms. Hine?
That is, Judge. We've got a couple things that issued the parenting class. Mr. Ross would also like to petition the court to use his NOLO plea as well.
All right. Ms. Duncan, please proceed.
Yes, Your Honor. In this case, the state's offer for the simple battery family violence in the case ending in 226Y was 12 months to serve, 30 days, credit for time served, 15 days, balance probated, no further contact with Miss Shanteria Brown in a 24-week family violence intervention program and a parenting class. From my calculation, this defendant has served 15 days total. In this case, the parenting class was requested because on the date of July 29th, July 29th, 2020, this defendant did in fact batter the victim by who is the father of her child after he came to speak to her about paying child support for the children. he was upset about it and he attacked her by grabbing her and slinging her around the apartment. The warrants did indicate that at that time, there were 2 children present for that attack, and they did witness that attack. Only reason there is not 2 counts of cruelty to children, because as the statute necessitates, it needs to be a predicate charge of battery. So that's the reason for the parenting class. We believe that it's a specific concern for these particular victims, given that this incident did arise over having to pay child support for those children. So we believe the state's offer is more than reasonable in this case. Also, given the fact that this defendant did FTA for jury trial with Judge Edie on June 23rd, 2022, and there was a bond forfeiture judgment entered on November 8th, 2022 for this defendant. He does have 6 cycles. He had a NOLO for carrying a weapon without a license in 2014. There was a marijuana NOLO in 2014 as well, and a marijuana conviction in 2015 of those 6 cycles. So the state would be opposed to this defendant using a NOLO. Nothing further.
You said the state would or would not?
Would be opposed.
Would be opposed. All right. I'm gonna sound for the victim at this time. Is Ms. Shanteria Brown on the Zoom conference? All right, hearing none. And to clarify, you said no contact at all, Ms. Duncan?
Correct.
Or was
No,
it- No
no
further?
contact.
All right. Ms. Helen?
Yes, Judge, I also read that warrant. I did not see the allegations that there were children present. Again, Judge, I also didn't see any charges for cruelty to children to indicate that that actually happened, Judge. So when I went and spoke to Mr. Ross, he has had no contact with Ms. Brown. As you can see, this is about a 2-year-old case. So he's been following the no contact, Judge. He does share a child, a 6-year-old boy with Ms. Brown, who he's had third party drops off with her. So he has had no contact with Ms. Brown and has been doing what he needs to do as far as parenting with his 6-year-old son. So Judge, we don't see the basis for the parenting class. He does want to do the 6 months of the Family Violence Intervention Program. He's willing to do that, Judge. But I am asking for that parenting class to be waived. Currently, he does have contact with his 6-year-old son that he shares with Ms. Brown. And I didn't see any allegations that would show that he would need a parenting class for that, Judge. It is time served, and we do again agree to the 24 weeks of the Family Violence Intervention, but Mr. Ross has lost all employment due to incarceration. So we are asking for those probation fees to be waived for the entire probation period so that he can complete the 24 weeks and report to probation continuously, Judge. So we are asking for the time served basis, the 24 weeks of the Family Violence Intervention class, and for those probation fees to be suspended for Mr. Ross so that he can complete probation successfully.
And
All
Your
right.
Honor, if I may clarify for the record quickly, it was not the warrant, it was the police report, and it did indicate that there was a 7-year-old child with the initials MM present and a 3-year-old child with the initials of JR present during the attack. And as the state has previously stated, there cannot be cruelty to children charges within a predicate offense of simple battery, since there was no visible injury, but she was thrown around the room. Nothing further.
All right, I'm gonna accept the defense's recommendation. I will only waive 6 months of fees, however, and he will be required to report to probation the entire time, even after completion of the VIP class. He will also complete the 24-week family violence intervention class, and he can continue that third-party contact. Does your client still want to take the plea today, Ms. Helen?
Mr. Ross agrees, we accept that, Judge, and thank you for the waiving of the 6 months of those fees.
All right, Mr. Ross, please raise your right hand. I'm gonna place you under oath for the purposes of taking this plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone promise you anything in exchange for taking a plea today?
No.
Did anyone force you to take a plea?
No.
Are you satisfied with Ms. Helen's representation?
Yes.
And you understand you'll have no further court dates regarding this charge of simple battery if you take this plea today?
Yes.
And you're giving up your right to confront your accusers or present any evidence you may have had?
Yes.
And you understand the requirements that you must continue that third-party transfer of your child, have no contact with Ms. Brown, and complete the 24-week family violence intervention program.
Yes.
As to the charge of simple battery family violence, Mr. Ross, how do you plead?
No.
I accept your no vote plea at this time. Is there anything further from either party?
No, Judge.
Nothing
All
further
right.
from the state.
All right, best of luck to you, Mr. Ross.
Don't plead on probation.
That concludes your case. Who do we have next?
Position 26, Sills.
Okay.
Thank you, Ms. Walsh.
All right, good morning, Mr. Sills. Your case is 20 CR 005589Y. In this case, you're charged with battery, family violence, 2 counts, simple battery, family violence, reckless conduct, and theft by taking, each with the offense date of November the 12th. Do you understand your rights?
Yes, sir.
It's my understanding that this is a negotiated plea. Is that correct?
That is correct, Judge.
All right, thank you. Ms. Duncan?
Yes, the state's offer in this case for position 26, the case ending in 589Y. For count 1, it's 12 months to serve, 154 days. Credit for time served, 154 days. Balance probated, 24-week family violence intervention program. No further contact with the victim in this case, who is Miss Sarah Sims. Stay away from the incident location, which is 10945 States Bridge Road, or wherever the victim resides. For count 2 of battery family violence, it will merge with count 1. For count 3, state's offer is 12 months probation to run consecutive with count 1, and count 4 is time served. And the factual basis for that is on the dates of November 12th, 2020, and November 17th, 2020, there were physical altercations that led to visible injuries between the defendant and the victim, in this case, Sarah Sims. There was an altercation where the defendant in this case struck Miss Sims in her eye and struck her several times while she was driving a vehicle. And the altercation got physical while she was driving, and it is alleged that he grabbed her keys and threw them out of the car. That is the state's basis for this, and this defendant does have 4 cycles out of Georgia, and this case has been reset several times, so we do have some concerns about the risk of reoffense, but given the time served, we think our recommendation is more than appropriate in this case. Nothing further.
Yeah, it's 5 counts, so we're missing 1, I believe. 1, 2. What about the 5th count, the theft by taking?
I have that, Judge. I have that theft by taking listed here under the plea. Is that
Right, but I'm saying Ms. Duncan gave us recommendations for 4 counts.
Okay, I'm sorry, 1 second. I'm sorry, for both of the battery family violences, it's the same recommendation for count 1 and count 2. And for
Okay.
count 3, it's going to merge with count 2. Count 4 is the reckless conduct, is 12 months probation to run consecutive with count 1 and count 2. And count 5 is time served.
Your Honor, that is not our understanding of the plea. The plea that was offered had for the first offense of battery family violence, 12 months to serve, 154 days. Credit for time served, 154 days. Balance probated to 24 weeks of the family violence intervention program. Count 2 was from the plea offer to merge. Count 3, 12 months, serve 154 days, credit for time served 154 days, balance probated. And then count 4 is time served. So Judge, that was not our understanding of that plea. And if we need to go non-negotiated so that we can have that second battery family violence merge, we can do that.
I'm trying to understand what
I'm trying to get this, hold on 1 second. Okay. Let me see. So the state's offer is count 1 would be the time served plus the FVIP. Count 2 would have merged with count 1. Count 3 would have been the probation. I'm just trying to understand. Ms. Duncan, say it again. What was the state's offer?
Ms. Olet, could you clarify for the court?
That's
Okay, so
correct, Your Honor. I think we were missing an offer on the reckless conduct or the theft by taking. I think we failed to realize I failed to realize that there were charges. The reckless conduct can merge with the simple battery or the
So he
battery.
would be, so he would essentially be pleading to one count of battery, one
And then-
count, and one count of simple battery, and then one count of theft by taking?
Yes, Your Honor.
Okay.
And that was not your understanding, Ms. Helen?
Well, if that is what the offer is now, that is what we understand. If it's one count of battery, family violence, one count of simple battery, family violence, and the reckless conduct, that is our understanding at this point, Judge.
Okay, so the reckless is merging, not the theft by taking? Just want to clarify, what are the remaining charges now? What are the charges that now remain, Ms. Gillette?
The state's intent was that he would plead to one count of battery family violence, one count of simple battery family violence, and one count of theft by taking.
Okay.
If that's going to be an issue, then we may need to go to a breakout room.
No, that's
Alright.
fine, Judge. We just wanted to make sure we got the clarification this morning, so that Mr. Sills and I understand what he's pleading to. One count of battery family violence, one count of simple battery family violence, and one theft by taking. I think there was allegations of a phone thrown near a tree line. So if those are the three charges, Judge, we do understand, and that's what we do accept.
All right. All
That's
right,
correct.
all right, so now it's negotiated once again. All right. So defendant will be taking a plea, let me just clarify one more time, to one count of simple battery. And the recommendation there is 12 months credit for the time served, 154 days, the FFIP class. The simple battery, for which he will serve 12 months probation, and the theft by taking, for which he will receive time served.
That is correct, Your Honor.
All right, is that your understanding, Ms. Helen? And do you stipulate to the factual basis, ID, and venue?
That is our understanding, Judge. We do stipulate to the factual basis, venue, ID, and we do accept that plea as negotiated.
All right, Mr. Sills, I'm gonna ask you some questions to make sure you're taking this plea voluntarily. Will you please raise your right hand? Do you swear and affirm the testimony you give today will be
I'm
the truth?
joined without video.
Please mute. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Do you understand that by taking this plea, you'll have no further court dates regarding these particular charges?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements
Yes, ma'am.
that you have to complete those courses and you're to have no contact with the victim in this case?
Yes, ma'am.
As to the charges of battery, simple battery, and theft by taking, Mr. Sills, how do you plead?
Guilty.
I accept your guilty plea. Is there anything further from either party?
Yes, Judge, I apologize. I didn't ask for those probation fees to be waived. This is a probated sentence. We are asking for at least 6 months of those probation fees to be waived for Mr. Sills so that he can successfully report to that misdemeanor probation.
All right, we will waive 6 months of fees for Mr. Sills. All right. All right, that should conclude his case if there's nothing further. I need a very brief recess. We'll be back in about 1 minute. Please
Thank
hold
you.
everyone. Thank you.
Thank you.
So 6 months, wait. Want to write that down for each one? Okay, just so. If you ever want to get a copy of that, just 3 charges.
Francois,
Any other questions?
Yeah.
No, that's it.
You wanna
not go
go?
next.
Yeah, that's cool.
All right.
All right. Hey, Duffy, who's your guy for, so I can let Helen or McLean know?
Mhm.
What
Who's-
was it,
27.
27? Okay. That's somebody Helen, okay.
All right, let's continue.
Okay, well, awesome. Any questions?
All right, who do we have next?
Position 27, Mr. Simpson.
All right, good morning, Mr. Simpson. Your case is 22 CR 006277Y. In this case, you're charged with theft by receiving stolen property with the offense date of April the 15th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. This proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can log on and watch this. Do you understand your rights today?
Yes, ma'am.
All right, thank you. The announcement I have, Ms. Helen, is that this case will be arraigned and that we're going to conduct a bond hearing.
Correct, Judge.
All right. All right, let me arrange this case then. Mr. Simpson, in case 22 CR 006277Y, you've been charged with one count of theft by receiving stolen property, which has been formally accused by the Solicitor General of Fulton County, Georgia. Ms. Helen, do you waive a formal reading of the accusation?
I do, Judge.
I appreciate that waiver. At this time, your case will be reset for trial and the trial will be scheduled by the state court judge to whom this case is actually assigned. Please make sure that you keep your address and any phone numbers current with the court should you make bond. You do not have the burden to prove the charges against you at trial. The state represented by the Solicitor General bears that burden. If they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Simpson, how do you plead?
Not guilty.
I accept your not guilty plea at this time. All right, let's commence the bond hearing. Ms. Duncan, please give me the state's position regarding bond.
Yes, Your Honor, the state's position regarding bond on this case is going to be a $2,500 surety bond. In this case, we do have some concern about the risk of reoffense. This defendant originally received a UGR with parental cosigner. And this case was originally a felony. However, it was transferred down to state court. At that time, he was given the benefit of a UJR. This defendant does have a current open felony case in Fulton County Superior Court. That's 22 CP 211431. And on that case, he received a $20,000 surety bond for theft by receiving stolen property, felony fleeing, harassment of an assistance animal or police animal. On August 12th, 2022. And in this case, it did occur on April 12th, 2022. And the defendant, well, officers responded to a carjacking call from a Mr. JAYKISHA Patel, who stated to officers that his Honda Pilot had been stolen. They were able to track the vehicle because the victim in that case had left its AirPods in the car. Upon tracking the vehicle to the location, they were able to identify that there had been 2 black males who had entered the vehicle at that time, and those suspects were identified as the defendant and another party. And there were several items that were identified as being stolen in that entering of that stolen vehicle that are listed in the warrant. There was U.S. currency, an Indian passport, and several other things, and 2 suitcases. So the state believes, given the risk of reoffense present in this case and the fact that this defendant does have an open additional theft by receiving stolen property case, that the $2,500 surety is more than reasonable. And this defendant has already been given the benefit of a UJR while out and did commit further felonies. So nothing further from the state.
All right, thank you. Ms. Helen?
Yes, Judge. This is a bond hearing for Mr. Jonquavia Simpson. I do hear that open case. Can I get pretrial to read his history though, please?
All right, is there someone from pretrial on the line? Good morning, Ms. Jackson. Can I please have this defendant's history, please?
The defendant has 4 cycles. The defendant's last arrest was July the 27th, 2020. in Fulton County for theft by receiving stolen property. The defendant does appear to have an open case pending in Fulton County for theft by receiving stolen property and fleeing or attempting to elude an officer. That case number is 22 CP 211431. There are no convictions listed in the GCIC, Your Honor. Nothing in addition.
All right, thank you. Ms. Helen.
I did speak to Mr. Simpson, and so he did tell me about this history. Those cases are still open. He's taking both of those cases to a jury trial because even as the state said, it said it was another male and Mr. Simpson was identified. I think they're, again, still looking to see if that was the actual case in that felony hold. So he's definitely taking that felony case to a jury trial, Judge. But for this case in particular, we're having a bond hearing because we would like to request, number one, a $1,000 surety bond. Mr. Simpson is 17 years old. I spoke to his mom, Tanya Smith. She was not able to make it today, but she was that other parent that co-signed on that bond form. So he does have family support, Judge. He's also looking to get his GED. Being incarcerated has prevented him from completing that task, Judge, but he would like to do that. He helps his mother with his brothers and sisters. He has 9 total, 3 brothers, 6 sisters, and he helps his mother financially care for those other siblings, Judge. He's also looking for more employment. He lost all employment due to incarceration, Judge. He does have strong family ties here in Fulton County. He's a lifetime resident. Was born at Grady Hospital, Judge. So I do hear the history, but I talked to Mr. Simpson. I do not believe that there's a risk of reoffending. He is taking those open cases to a jury trial, Judge. He also has cousins and aunts and uncles, a large amount that live in Fulton County. So he has strong family ties. I do not believe he's a danger to the community. I don't believe he's a danger to any of the alleged accusers that are mentioned in this case, Judge. So we are asking for a $1,000 surety bond currently for this case. I did hear that he received originally a UJR, Judge, but when I talked to Mr. Simpson, he's taking that other case to a complete jury trial, Judge. He was not involved in that case whatsoever. And so for this case, Judge, we're asking for that $1,000 surety.
All right, I'm sorry. What were the conditions attached to Mr. Simpson's original bond? He was to have no contact with Mr. Patel, and was there a stay away location?
For this UJR, I didn't see in my research any other bond conditions, Your
No
Honor.
other conditions, okay. All right,
But as the state would just like to make clear for the record, Ms. Helen indicated that she doesn't see any risk of reoffense. The defendant was released on a UJR in this case and is alleged to have committed the same or similar offense within 3 months of being released. So the state believes our recommendation is more than reasonable.
all right. At this time, the defendant will receive a $1,500 surety bond. Hearing that there were no special conditions, I will not apply any at this time. All right, I believe that concludes Mr. Simpson's case.
And Mr. Simpson, that means you have now a $1,500 surety bond to this case, okay?
Yes, ma'am.
All right, best of luck to you, Mr. Simpson. Who do we have next?
Positions 22 and 23, Montgomery.
All right, good morning, Mr. Montgomery. Your cases are 22 CR 006603G, in which you're charged with criminal trespass. And case 22 CR 007739G, in which you're also charged with criminal trespass. You understand your rights today?
Yes, but
All right, it's my understanding that this is a negotiated plea.
yes, but
Yes, Your Honor, it is.
All right, Ms. Duncan, please proceed.
Yes, Your Honor, would you like me to start with position 22?
Yes, you can do them, actually do them both together. Start with 22 and then do 23.
Okay, the state's recommendation in position 22 is 12 months to serve, 6 days, credit for time served, 3 days, with the balance suspended and a stay away from the incident location, which is 225 Peachtree Street, which is the hub. In that case, Your Honor, the defendant was on private property, which was the hub at that time when he had been he been asked to leave and refused to leave that property. Officers were contacted and he was taken into custody. For position 23, the state's offer is 12 months to serve, 40, let me see, I'm sorry, let me make sure my math is correct. 12 months to serve, 42 days, credit for time served, 21 days. And balance suspended, stay away from the MARTA station located at 216 Peachtree Street. In that case, Your Honor, the defendant did knowingly enter the Peachtree MARTA station after being issued a criminal trespass warning 30 minutes prior. He returned to that property. Nothing further from the state.
All right, Ms. Helen, was that your understanding of the state's offer, and do you stipulate to factual basis, ID, and venue in this case?
That is our understanding of the offer, Judge, is the time served, no probation officer. Mr. Montgomery does accept that, and therefore we do stipulate to the factual basis, venue and ID, Judge.
All right, Mr. Montgomery, I'm going to ask you some questions to make sure that you understand and are voluntarily taking this plea. Will you please raise your right hand?
Yes, sir.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and
Yes,
under the penalty of perjury?
Yes, sir.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, sir.
I'm sorry,
No, sir.
you're not? Okay.
No, sir.
All right. Are you satisfied with Ms. Helen's representation?
Yes, sir.
All right. And do you understand that by taking this plea, you're not going to have any other court dates regarding these two cases?
Yes, sir.
And you understand, did anyone promise you anything in exchange for taking a plea?
No, sir.
And you understand that you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, sir.
And you absolutely understand that you cannot go back to either the hub or the MARTA station located at 216 Peachtree Street?
Yes, sir.
All right, as to the charges of criminal trespass in both cases, 6603G and ending in 7739G, Mr. Montgomery, how do you plead?
Guilty.
I accept your guilty plea. Is there anything further from either party?
No, Judge, thank you so much.
All right, best of luck to you, sir. That will conclude your case.
Next is position number 29, Mr. Dawson.
All
Yeah,
right.
good morning, ma'am.
Good morning, Your Honor. The state would just like to make the court aware that this case has been accepted as a felony transfer and the order has been submitted.
Okay. Is the transfer order have already been sent to me?
Yes, it was sent to Ms. Champion.
And there's already a felony case number assigned to it?
It was accepted by ADA John Turner this morning, so I'm not sure that there's a felony number already.
Okay. All right.
And which position was that, Your Honor?
Position 29. So, Mr. Eric Vassal? so
Yeah, how you
your-
doing, ma'am?
Good morning. Your case has been accepted by the DA's office. So this case will not be heard by me today, all right? Please get in touch with your attorney. She'll give you some further
Hey,
information.
but hear what I'm saying, though. Let me ask you something. I know they clocking you. I know they clocking you.
Okay.
I hear what I'm saying, though.
You have a right to remain silent. Anything you say can be used against you.
Hey, put me up for a speedy trial.
All right.
I'm not in jail for that.
All right. Will you speak with
Yeah,
Ms.
put me down
Helen?
for
Ms.
a
Helen,
speedy
will you speak with
That
your
ain't
client
what
following
it
this
is,
hearing?
I can, Judge.
All right, Mr. Vassal, so your case will be reset and you'll speak with Ms. Helen, who will give you some information about future court dates, all right? Best of luck to you, sir. That concludes your case.
Position 18, Jones. Country case.
It's Mr. Lynch.
Good afternoon, Your Honor.
Good morning. It's still morning yet. Good morning, Mr. Lynch.
Good morning, I'm sorry.
No, I'm used to seeing you in the afternoon as well. All right, the announcement for this case, the case of Michael Jones. What's your announcement, Mr. Lynch?
Your Honor, we can either waive formal arraignment. We haven't come to a resolution here, so we can waive formal arraignment and enter a not guilty plea if that serves the court's interest.
All right, are you asking to be heard on bond at this time?
Judge, not at this time.
All right, so Mr. Jones, what's happened today is your attorney is gonna waive arraignment, which means that they're gonna waive the necessity of having you take a not guilty plea. Your case will be reset for trial and you'll stay in communication with your attorney between now and then. All right?
Yes, ma'am.
All right, that concludes your case today, Mr. Jones. Best of luck to you, all right? Thank you, Mr. Lynch, for that. Does that conclude your business today?
That does, Your Honor. May I be excused?
Of course. Have a great rest of your day, Mr. Lynch. Take care.
Thank you, Judge.
All right.
Position 19, Kumar.
All right, the announcement that I have for this case, Ms. Helen, is this is a non-negotiated plea.
That is correct, Judge.
All right. All right, Mr. Kumar, your case is 22 CR 0077. I'm sorry, 7877Y. In this case, you're charged with 1 count of simple battery and 1 count of simple assault, each with the offense dates of November the 18th of 2022. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Duncan, please proceed.
Yes, the state's recommendation in this case was 12 months to serve 30 days. The defendant has served 14 days in this case, so we will be asking for 1 additional day with the balance probated, a 2-week anger management, a stay away from the incident location, an MHET, and no further contact with the victims in this case. From my research, this defendant does have 8 cycles, is a multi-state offender, 7 out of the state of Georgia. And those cases do include a probation violation arrest in 2013 and an FTA in 2021, and the possible open case out of Chamblee from 2021, as well as a death by shoplifting conviction in 2001, a simple battery conviction in 2012, and another theft by shoplifting conviction in 2021. In this case, Your Honor, it did occur on November 18th, 2022. Officers were patrolling the Lindbergh area MARTA station, and they were dispatched to a call regarding an unknown female assaulting a female. Upon officers arriving, they met with the victim in this case, who stated to officers that she was on the northbound train and she encountered the defendant in this case. And he started to yell obscenities at her and curse at her and use racial slurs towards her. She stated that this defendant did also verbally threaten her by saying that he was going to fuck her up and kick her ass, and continue to additionally use racial slurs towards her. She stated that while she was exiting the train at that time, he continued to follow her, and he got in her face and continued to use racial slurs, and in fact did spit on her at that time. And all of these incidences were caught on surveillance footage at the Lindbergh train station. Your Honor, that is the basis of our recommendation. We do think that 1 additional day is warranted given the nature of the offenses alleged, and given that this defendant does have a prior simple battery conviction. We believe 1 more day would be sufficient to round out the accountability for this case and this process, as well as the other requirements. We believe they are necessitated given the account of the offense alleged. They don't know each other. So we do have some concern about the risk of reoffense and the danger to this particular victim that this defendant would go up to an unknown female at that and make these types of remarks, call her out of her name and use racial slurs. So we want to protect this particular victim and the other citizens of our county, and make sure that this defendant is being held accountable for these actions. So we believe our recommendation is more than reasonable. Nothing further.
Ms. Jackson, can I have his history, please?
Yes, Your Honor. The
Thank you.
defendant has 8 cycles. The defendant's last arrest was December the 20th, 2021 in Chamblee, Georgia, for a failure to appear. The underlying charge was theft by shoplifting. The defendant does have misdemeanor convictions, 1 in 2021 for theft by shoplifting, 1 in 2012 for simple battery, 1 in 2001 for theft by shoplifting. Nothing in addition, Your Honor.
All right, Ms. Helen.
Yes, Judge, this is a non-negotiated plea for Mr. Kumar specifically. We had a couple of concerns with number 1, the jail time. We're asking for time served for Mr. Kumar. He is homeless. And we all do know that it's quite dangerous here in the jail. And Mr. Kumar has experienced some violence as well as threat and intimidation from other inmates here, Judge. So we are asking for time served for his safety. And then, so the second thing, the alleged accuser walked up to Mr. Kumar and said, "Get the fuck out of my country." Mr. Kumar has been in Georgia for the last 20 years. He's quite a citizen of this country. And so it was a verbal argument with that young lady in which he was trying to defend himself. He stated he did not make any contact with her whatsoever and merely wanted to get away from the situation because that young lady was loud and very verbally aggressive towards him on the MARTA train, Judge. That is why we're asking for time served. The MHET, Mr. Kumar has displayed no concerns of mental unwellness or lack of competency about what's going on. There was a verbal argument with a young woman who told him to get the F out of this country on the train, and he wanted to just defend himself and let that young lady know, hey, I'm on this train, I'm just riding it just like you. So Judge, we're asking for time served. He is homeless. And even so, being homeless, he's been in Georgia for the last 20 years and only the 8 cycles, Judge. This is not a violent offender. He's not violently offending towards anyone else. He talked to me about that 2012 case. It's not the same person in this case, Judge. So I don't believe there's going to be any type of violence threatened towards any other communities in Fulton County or racial slurs, Judge. We are asking for time served for Mr. Kumar. We are asking for balance suspended. Again, he cannot afford those anger management. If the judge feels that some type of course can be taken, we are asking for some type of community service in exchange for those anger management classes. He cannot afford those. I believe there's $60 or more per class. He can't afford that, Judge. He also does work, even being residentially challenged. He does have a dish job, Judge. If he is not released within this week, that job will be gone. And so, Judge, we are asking for time served, balance suspended. The MHET, we don't see the basis of that. The 2 anger management classes, if the court feels that Mr. Kumar would need some type of substitute for that, we are asking for community service for that, Judge.
All right.
Okay,
If Mr. Kumar takes the plea today, he will have to serve the one additional day at the Fulton County Jail and complete the 2-week anger management courses. I will not require the MHET. Does your client still want to take that plea?
Yes.
Yes, Judge.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with Ms. Helen's representation?
Yes, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand you'll have no further court dates regarding this, and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Repeat the question one more time for him, Judge.
You're giving up your right to a court date and to have the state prove these charges against you. You understand that?
Do you agree to give the right to a jury?
No.
You understand you're not gonna be able to go to court about this. This will be the last time. You're not gonna be able to defend yourself against these charges?
Yes, ma'am.
All right, as for the charges of simple battery and simple assault, Mr. Kumar, how do you plead?
Guilty.
I accept your guilty plea. Is there anything further from the state or defense?
This is a probated sentence. Can we just have those 6 months of probation fee so that he can complete the?
I'll waive all probation fees for him in light of his situation. All right, anything further?
nothing further.
All right, we're gonna be on a very brief recess. Thank you. And for the purposes of the record, the stayaways will apply to Mr. Kumar's case. Ms. Duncan, I'm sorry, will you please give me the stayaway address?
The stay away address for Mr. Kumar is going to be, let me see, where is it? Which screen is it on? It is position 19. It is the Lindbergh train station.
Okay.
And what's the address for the Lindbergh train station?
1 second, I'll Google it. The Lindbergh MARTA station is located at 2424 Piedmont Road Northeast, Atlanta, Georgia, 30324.
All right, so Mr. Kumar must stay away from that location.
Understood, Judge.
All right, who do we have next?
I'm sorry, Your Honor, and to clarify, there'll be no further contact with that victim, correct?
Yes, and no further contact with that victim.
Position 33.
All
Mr.
right.
Williams.
Good afternoon, Mr. Williams. Your case is 22 CR 00770-8J. In that case, you're charged with battery with the offense date of August the 2nd of 2022. Do you understand your rights?
Yes, ma'am.
All right. Oh, well, let me explain your rights. You haven't heard them. You have a right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. Also, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this particular proceeding. Do you understand that, Mr. Williams?
Yes, Your Honor.
All right, wonderful. Okay, the announcement that I have for this case is that this case is gonna be arraigned and we're gonna have a bond hearing. Is that correct, Ms. Helen?
That's correct, Judge.
All right, Mr. Williams, at this time, I'm gonna arraign your case, which means that I'm gonna formally reset it for trial, all right? Mr. Byron Williams, in case 22 CR 00770-8J, you've been formally charged with 1 count of battery with the offense date of August the 2nd of 2022. Ms. Helen, do you waive a formal reading of that accusation?
I do, Judge.
Thank you. At this time, your case will be reset for trial, and the trial will be scheduled by a state court judge to whom the case is assigned. At this trial, you will have the right to an attorney, just as you've had today. You do not have the burden to prove those charges against you. The state represented by the Solicitor General bears that burden. And if they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Williams, do you plead not guilty to the charge of battery?
Yes, ma'am.
I accept your not guilty plea at this time, and your case will be so reset. Ms. Duncan, well, before I go to Ms. Duncan, Ms. Jackson, can I have his history, please?
Defendant has 24 cycles. The defendant's last arrest was February the 2nd, 2019 for simple battery. And that was with the City of Atlanta Police Department. Let me scroll down just to check and see if there are any convictions for you, Your Honor.
All right, thank you.
I do see a misdemeanor conviction that was in 2019 for battery. Just want to continue to check and see if there were any more. Do see one that was in 2007 for battery.
All right, I think that should be sufficient if you're not saying anything more current. Ms. Duncan, please proceed.
Your Honor, in my research, I did see those battery convictions, 2 of those from 2007. I also saw a disorderly conduct from 2018, an aggravated assault from 2019. The victim in that case was Trudy Scott, a family violence battery as well, and felony battery family violence as well. 2019, and the victim in that case was Trudy Scott. Additionally, I saw probation violations in 2009 and 2008 with a parole violation in 2013. There was a simple battery and battery arrest in 2014 that was dismissed, and a possession of cocaine arrest that was dismissed in 2016. Additionally, I saw that this defendant had an open felony case, according to the GCIC and our case manager, with the case number of 22 CP 213868. That was 2 counts of aggravated assault, possession of a firearm during the commission. In this case, Your Honor, there is, I believe, a $3,500 surety. The state in this case believes that is more than reasonable. The factual basis for this incident is that on August 3rd, 2022, officers were dispatched to 532 Cleveland Avenue Southwest, apartment 4E, by the victim in this case, Ronald Oglesby. That's Ronald, common spelling, Oglesby, who stated that his friend was over and that his friend had started to cause trouble. And after he asked him to leave, he was attacked and struck and jumped on by the defendant in this case. A result of that attack is that the victim did have a laceration that was bleeding under his right eye and swelling as well. Given this defendant's history, we do have concern about the risk of reoffense, given that according to the research, as indicated, this defendant does have several violent convictions and some of an aggravated nature, as well as we have some concerns that this defendant is a danger to the community. He continues to commit violent offenses while out on the streets of Fulton County. So we believe that that $3,500 surety is more than reasonable in this case. Nothing further from the state.
All right, thank you, Ms. Duncan. Ms. Helen?
Yes, Judge, this is a bond hearing today for Mr. Williams. When I went and spoke to Mr. Williams, he's not accepting any plea of guilt because he was defending himself in this current case that I'm over with the battery for Mr. Ronald Oglesby. Let's just get into the Ayala factors. Mr. Williams is 59 years old. He is, prior to being incarcerated, he was gainfully employed as a factory worker at the metal plate. He also worked with a couple of work agencies and warehouse. So he's employable, Joy, and he's been working prior to being incarcerated. He has 3 kids. He is a family man, Judge. 2 boys, 1 girl. He is from Chicago, Judge. However, he's been in Georgia for the last 22 years in Fulton County. Okay. And so he also has some good community ties. He worked at the local food bank. He also has worked with the Atlanta Baptist Rescue Mission. He has been added as a member to that mission as well. He also is a good Samaritan. In 2020, he actually saved someone's life here in Fulton County, Judge. Called the police so that they could come out and see what was wrong with someone who was suffering in front of him, Judge. And so let's get into the allegations of this battery. He was defending himself from Mr. Oglesby, who stated he was just a friend who showed up to the apartment. Mr. Williams has lived at that address for the last 2 years, since 2020. So he was not just some random person who showed up. He lives there, Judge, and he has been living there since 2020. This particular Oglesby had been stealing and taking things from him and began a verbal altercation with him. And that verbal altercation turned physical when Mr. Oglesby picked up a stick and hit Mr. Williams in the left side of his cranium. So Mr. Williams was trying to protect himself from Mr. Oglesby offering him violence. Judge, we are asking for a $1,000 surety bond. I do hear the allegations of the aggravated assault. I spoke to Mr. Williams. That is also another case of self-defense. So Judge, he's taking all of these cases to a jury trial to show and prove his innocence, Judge. So we are asking for a $1,000 surety. I do hear the simple, or at least the 2019 battery misdemeanor. I do not believe that that was with Mr. Oglesby. With the current open cases, Judge, he is taking that to a jury trial, and we are asking for a $1,000 surety bond on that battery.
All right, thank you. And I'm sorry, Ms. Helen, when you were saying he lives there, Can you clarify where you meant? Are you saying he lives at that Cleveland Avenue address?
He does 532 Cleveland Avenue, Southwest Atlanta, apartment 4E. He lives there and has been living there since 2020.
Okay, and is the allegation that the victim does not reside there?
That is the allegation. Mr. Oglesby stated he didn't know where Mr. Williams lives. When I spoke to Mr. Williams, he has been residing there for 2 full years.
And
Okay.
that is not what the state has in terms of what the officers were told in the warrant.
Okay, what were the officers told regarding the address at 532 Cleveland?
The officers were told that that was Mr. Oglesby's residence and that the defendant was over, but he began to cause trouble. And then Mr. Oglesby asked him to leave, and then that's when he was attacked. Because Mr. Williams is alleged to have become upset and began jumping on him and punching him about 4 or 5 times in the face, causing those visible injuries that I stated.
All right. At this time, I'm going to lower the bond slightly to the defendant will receive a $3,000 surety bond. He is to stay away from that incident location. He can return one time with a member of law enforcement to ascertain whether or not that's his address. If it is Mr. Oglesby, of course, he must stay away. He is to have no contact with the victim, in this case, Mr. Oglesby. And he is to have no weapons, drugs, or alcohol as a condition of this surety bond. Is there anything further from either Ms. Helen or or Ms. Duncan?
No, Judge.
Further.
All right, best of luck to you, sir. What do we have next?
Position 14, Glenn.
All right. Good morning.
Can we go to another position of mine? Mr. McLean is still speaking with one client.
Okay.
Oh, he's on screen. Okay.
I need to convey the state's response to his counter offer to Mr. Glenn and get his response to that, and then we'll be.
All right, so Mr. McLean needs to speak with his client. So can we go to another position?
If he could call, if Mr. Glenn could get on the phone and call 22390.
There's no phone up here for him to call you. Have to do a breakout. I don't have a phone.
We do break it. Okay.
All right. Position 30, Mr. Baluna.
All right, good morning, Mr. Villanueva. Your case is 18 CR 0084081. In this case, you're charged with 1 count of battery, substantial physical harm with the offense date of September the 1st of 2018. Do you understand your rights today?
Yes.
All right, the announcement I have is the same, that this case is being arraigned and reset jail jury, and that we're gonna hold a bond hearing. Is that correct, Ms. Helen?
That's correct, Judge.
All right. At this time, sir, your case 18 CR 0084081. In this case, you've been charged with 1 count of battery, substantial physical harm, which has been formally accused by the Solicitor General of Fulton County. At this time, the case will be reset for trial, and the trial will be scheduled by the state court judge to whom this case is actually assigned. At this trial, you will have the right to an attorney, just as you've had today, and you will not have the burden to prove the charge against you at trial. The state, represented by the Solicitor General, will bear that burden in order to get a conviction. If they do get a conviction, you can face a sentence of 1 year in prison or a fine of $1,000. Based upon this information, do you plead not guilty?
Not guilty.
All right, I accept your not guilty plea. May I have his history, please, Ms. Jackson?
And Your Honor, I'm sorry to interrupt. The calendar says battery, substantial physical harm. However, in Odyssey, I'm seeing that this case is actually charged and accused as battery family violence.
Okay, let me see if I can pull the accusation myself. In the meantime, while I'm doing that, Ms. Jackson, can I still have the history, please?
It has 31 cycles. The defendant's last arrest was February the 23rd, 2021, for a probation violation in Cherokee County, Georgia. The defendant does appear to have an open case pending for battery, substantial physical harm. That case number is 18 CR 00840-8 in the letter Y. In addition to that, the defendant appeared to be on probation in Cherokee County for aggravated assault and terroristic threats act. That disposition date was November the 12th, 2015, and the term is for 10 years. The defendant does appear to have a history of probation violations. There was one in 2016, one in 2019, and one in 2021. Also, the defendant appeared to be a multi-state offender. He has arrests out of California and some out of Delaware as well. Nothing in addition, Your Honor.
All right, thank you so much, Ms. Jackson. I'm trying to confirm that this case, pretrial has just read the same case number and said that the charge was battery, substantial physical harm. Ms. Duncan, you're saying that Odyssey shows a different charge when we put in this number?
Yes, Your Honor, that is what I'm seeing. I'm seeing battery family violence. And when I click in the documents and I pull the accusation.
Okay, yeah, that is what we have as well. All right, so the charge as read on the accusation is not battery, substantial physical harm, it's battery family violence. For clarification, I'm going to read it. It reads, I, Keith E. Cameron, Solicitor General of the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Jesus Villanueva with the offense of battery family violence, a misdemeanor said in the County of Fulton, State of Georgia, on or about September 1st, 2018, did intentionally cause visible bodily harm to Jose Rojas Rangel, who is the other person living in the same household as said accused in violation of OCGA section 16-5-23.1 F1, contrary to the laws of this state, the good order and peace and dignity thereof. All right, so with that information and all the same information, Mr. Villanueva, how do you plead to the charge of battery family violence?
Not guilty.
All right, I accept your not guilty plea. All right, we've heard the history. Ms. Duncan, please proceed with your argument regarding his bond.
Yes, Your Honor. In this case, this defendant currently has $1,000 surety bond. This is a rearrest. This defendant has been waiting for a jury trial and has since been rearrested on additional charges. Those additional charges are I believe they are felony in nature, so that original signature bond that this defendant did receive has been converted to a surety bond. In this case, yes, it's 3 counts of trafficking in illegal drugs and a VGSA charge for which he is currently on $100,000 surety bond. In addition to this $1,000 surety bond that has been converted. In this case, Your Honor, the state believes that that $1,000 surety is more than reasonable. Given this defendant's history of probation violations, we don't believe that he has a good likelihood of success in response to the legal process while out on probation. We also have some concern about the risk of reoffense. It was indicated that this defendant is on probation for aggravated assault, as well as being a multi-state offender. So this does give us concern about the particular safety of the citizens of this community. And in this case, both the victims, Mr. Jose Borges Rangel and Brittany Garados, were living with the defendant in this case when he got upset with them about not paying rent. And he, in fact, attacked those victims, leaving visible abrasions that officers noted. And then it was indicated at that time to officers that he had, in fact, pulled out a knife and threatened to kill Miss Brittany. However, given that allegation, officers did not charge him with aggravated assault. However, they did indicate that there were visible injuries to both parties because of the attack. As alleged, he's been waiting for a jury trial since 2020. However, at that time, it was no virtual jury trial available. So while he was out on this bond, he was given the benefit of a signature bond at first, and he continued to commit felonies while out. So we do believe that $1,000 surety bond is more than reasonable in this case.
All right, thank you. Ms. Helen?
Yes, Judge. This is a bond hearing today, and Judge, I have heard his history read. When I went down and spoke to him, he is from California, but he's been in Georgia for the last 25 years, specifically in Fulton County and Cherokee County, Judge. He also is a proud father of 3 boys, 17, 18, and 21. They currently live in Marietta. So he does have strong family ties here in Georgia. I don't believe he's going to be a flight risk, Judge. When I went down and spoke to him, he also has community service history. He's also worked at the Recycle Center here in Fulton County. He's also done highway here in Fulton County, highway cleanup here in Fulton County as well. He's also worked with the Salvation Army as well. So Judge, I have heard his history. I do not believe he's a longstanding violent offender. I've spoken to him. He understands the seriousness of these current cases. And Judge, I have the year of 2018. I think that's our current case we're talking about. The aggravated assault, he's on probation. And I do hear the history of the probation violations, but he's been reporting to that probation and doing the best that he can with that probation, Judge. So I want that to be noted. We are asking for that $1,000 surety to be converted to a signature bond. I do understand the open cases, but those are allegations that Mr. Jesus is going to be fighting in a jury trial. He is not accepting any plea of guilt in that case, Judge. So for this case, we are asking for that $1,000 bond to be set as a signature bond as it was originally, Judge. Going through the Ayala factors, I don't believe he's a danger to any of these alleged accusers. It's 4 years ago. He has had no contact with those tenants who were tenants at that time. He has had no contact with them, does not want any contact, Judge. I don't believe he's a danger to our community. I don't believe he's a danger to be reoffending, Judge. He understands how serious these charges are. So Judge, we are asking for that bond to be modified to a $1,000 signature bond.
And my apologies to the court. I forgot to add that state with us that $1,000 surety remain as set with the additional condition of no further contact with either Mr. Jose Rangwell or Brittany Gordon Paz.
All right. At this time, the bond will remain as set as $1,000 surety, and he's to have no further contact with either victim. Anything further from either party?
Nothing further.
All right, best of luck to you, sir. That concludes your case at this time. What do we have next?
Is Mr. McLean ready for position 14, Glenn?
No, here's, let me get a microphone that'll work.
Okay.
Your Honor, the state and Mr. Glenn are in mid-conversation. They have responded to his counter offer. I'm going to convey that to him. But technologically, we can't, I don't believe, get on chat unless we have a keyboard to chat. And so if we can.
So you have no way to speak to your client, is what you're saying, Mr. McLean?
No, I have no way to speak to the state unless we do it on the telephone over here. Now, the state and I can talk on the telephone, but the client.
Right. Could Mr. McLean, could you chat your phone number of the phone number at the jail to Ms. Salette?
Oh, it's just a county extension. It's 22392.
Ms. Salette, will you please give the jail a call?
1 second. Can you say that one more time?
What's the number there?
23.
But Your Honor is correct. He's in a location where it is difficult for me to communicate to him. That is absolutely correct. I just, the first
So
thing.
after you speak to the state, are you gonna be able to speak to your client? There's no phone at 4 North, correct?
If there's no phone at 4 North, at some point, if we put him into the calendar, I'll just run it to 4 North, but I think it would assist the flow of the calendar if we put that last.
Okay. All right, so we'll have to take that position
The
later.
deputy hardly agree.
All
Mr.
right.
McLean, do you still need to speak with me?
Not really. I just need to convey the offer to him.
Okay.
All right, so we can't take that position now.
Right.
Right, who do we have next?
Position 6. 3
All right.
South.
All right, good morning. Your case, are you Julius Bradley?
Yes, ma'am.
All right, Mr. Bradley, your case number is 22 CR 007723J. In this case, you're charged with 1 count of battery family violence with the offense date of October the 8th of 2021. You have a right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have the right to an attorney here today at this particular proceeding. This
And Your
proceeding
Honor,
is broadcast over the internet as a live stream. It's also being recorded. I'm sure you're about to tell me it's been upgraded. I just don't want to get in his rights. All right. Do you understand your rights today, Mr. Bradley?
Yes, ma'am.
All right, is this, Ms. Salette, this case has been upgraded?
yes, Your Honor, that's correct. The DA's office has accepted this case as a felony.
All right, so Mr. Bradley, what that means is that this case is no longer before me. This case has been upgraded to a felony charge, and the DA's office will be handling the case from here. You'll need to stay in contact with your attorney who can assist you. You'll have a new court date whereby things will take place regarding this particular case. All right,
If I may, Your Honor, Mr. Bradley, do you understand the difference between what is being stated now versus what you and I discussed last night? Last night, we didn't have that it was accepted by the DA. Now, this court can't deal with it. You see the difference? You're going to have to deal with another court on this matter. We can't put up a plea now.
all right. So what, Mr. McLean, I'll ask that you maybe call Mr. Bradley and just explain that further to him later. But essentially, your case.
I'm sorry, Your Honor, I'm in the same building with them. As soon as court's over with, I'll go up and say hi.
All right, thank you. I appreciate that, Mr. McLean. Essentially, Mr. Bradley, it's no longer in this court. And Mr. McLean will explain further and answer any questions you may have, all right?
So am I still under the same bond that I've been had?
I'll let Mr. McLean explain all of that to you, all right? But there's nothing further that this court can do to address your case, okay? All right, that concludes your case today. And Mr. McLean will stop by later. Best of luck to you, Mr. Bradley. Who do we have next?
Position 17, Jackson.
And while Mr. Jackson is coming to the chair, could I inquire about number 11, whether it has been accepted yet or not?
Ms. Soletta, Ms. Duncan?
Yes, Your Honor. If that's Robert Davis, that
Yes.
case has been accepted
It has
by the
been.
DA's office, yes.
So that is identical in posture, Your Honor, to the case we just did, number
All
11.
right, can we have position 11? Is position 11 there? So I can just tell him that?
He is, he's right behind us, about a row or two back. Mr. Robert Davis, hang on. Want the office there. Thank you.
Okay, Mr. Davis, just as you saw me explain, your case 22 CR 007712A has been upgraded to a felony and it's been moved out of this court. So there's nothing further that either I can do to address your case at this time. Mr. McLean can explain further or address any questions you may have. All right, I just wanted to let you know that.
We'll do a second visit today in the visitation booth in Baltimore. Okay, thank you.
All right, we can go back to that position that we had before. What position was that?
17, Jackson.
All right. Good morning, Mr. Jackson. Your case is 22 CR 00. Good morning. Your case is 22 CR 007875C. In this case, you're charged with 1 count of possession of marijuana less than an ounce and 1 count of criminal trespass, each with the offense dates of November the 18th. Do you understand your rights?
Yes, Your Honor.
All right, the announcement I have is that this is a negotiated plea. So Ms. Salette, please proceed.
Your Honor, I understand from Mr. Jackson that he is not sure he wants to do a negotiated plea for this today. He may have changed his mind, which of course he has the right to do if that's true. Mr.
Okay, so if it may be non-negotiated, Ms. Jackson, can I have his history, please?
Yes, Your Honor.
Thank you.
The defendant has 7 cycles. The defendant's last arrest was September the 10th, 2022 for a charge associated with the CWAC, and that was in Fulton County. There's no that case appeared to be, the defendant received probation for that case. That case number is 22 CR 006122, the letter C. That disposition date is October the 4th, 2022, and the term is for 12 months. The defendant does have a prior felony conviction in 2021 out of Florida with theft of property. And I do see a hold out of Folkestone, Georgia, for a failure to appear. The date on that warrant was October the 22nd, 2019. I need to double check on that one. And the defendant has 1 misdemeanor conviction that was in 2019 for criminal trespassing. Nothing in addition, Your Honor.
All right, thank you, Ms. Jackson. Ms. Salat, please proceed.
Yes, Your Honor. The state's recommendation for the possession of marijuana is credit for time served. For the criminal trespass, the state's recommendation is 12 months served, 60 days, credit for time served, 13 days, balance probated, stay away from MARTA, and an alcohol drug evaluation and treatment if necessary. The basis for the state's additional time recommendation is that he was convicted on October 27th, 2022 of criminal trespass for trespassing at MARTA. And then he was also convicted on September 10th of 2022 of sexual battery, which occurred on a MARTA station. He has a permanent ban from MARTA. And in this particular case, he was back on MARTA property at the East Point MARTA station at 2848 Main Street, where he was on their property and officers saw him with a clear bag containing green leafy substance. So he is currently on probation for 2 cases, incidences that happened at MARTA within the last 3 months. He has a permanent ban from MARTA, as I stated previously. So at this point, the state thinks that additional jail time is necessary in order to convey the message that he does not need to go back to MARTA. Nothing further at this time.
How many days, additional days would it be?
It would have been 17 extra on that.
Correct.
All right, and Mr. McLean, you said
Your
that
Honor,
your client may not want to take that offer at this
Right.
time.
What he's really saying today, Your Honor, is that he's a young man who is just not making it in Atlanta, and he really wants to go back to Jacksonville. The thing mentioned about Folkestone, that's near Jacksonville. It's extreme South Georgia. Your Honor, he needs to get back to his family where the services are. He needs those services. He needs to get back to Duval County. Spoken with his parent rather, and I was on his previous case, and he's trying, but he's just not succeeding here in Atlanta, and he wants to go back home as soon as possible. So he's basically making a cry for mercy, throwing himself on the mercy of the court, and asking if he can get back a little bit quicker.
All right, when you say a little bit quicker, Mr. McLean, are you asking for time served on both, or are you proposing any additional jail time?
Precisely, Your Honor. If it could be time served, or even if it were 30 days to serve, that would be 2 extra days instead of 17. Something like that neighborhood of time served, yes.
Okay, and your position regarding the ADT, Mr. McLean?
Well, he can get that done in Florida as well.
All right. So to be clear, you're asking for 30 days and the state is requesting 60, as well as that stay away from MARTA. Is that correct?
Fair statement, yes.
All right. If defendant takes, I'm sorry, Ms.
Your Honor, I apologize for interrupting. I just want to make a correction. On that 2021 Theft of property, that was a misdemeanor, not a felony, and it was out of Florida.
Okay. All right, thank you, Ms. Jackson, for that clarification. If defendant takes this plea today, I would allow him to plea on the charge of criminal trespass to 12 months to serve 30 days, credit for the 13 days, and the balance probated, and he would need to stay away from MARTA and also undergo the ADET. Does your client wish to take that plea today?
Do you understand you would leave here in 2 days instead of 17 if you do this plea?
Yes, Your Honor.
You want to do that plea?
Yes, Your Honor.
Very good. Okay, thank you.
All right, Mr. McLean, do you stipulate to the factual basis, ID, and venue?
We do stipulate, Your Honor, to the 3 elements of ID, venue, and factual basis.
All right, please raise your right hand, Mr. Jackson. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do, Your Honor.
All right, thank you. You can put your hand down if it is, yes, you put it down. Are you under the influence of any drugs or alcohol at this time that will interfere with your ability to understand this proceeding?
No, I'm not, Your Honor.
Did anyone promise you anything in exchange for taking the plea today?
No, ma'am, Your Honor.
Did anyone force you to take a plea?
No, ma'am, Your Honor.
And you understand by taking the plea, you're not gonna have any further court dates regarding these 2 charges?
Yes, ma'am, Your Honor.
All right, and you understand the requirements that you absolutely cannot go back to get on MARTA under any circumstances?
Yes, I do, Your Honor.
All right, as to the charges of possession of marijuana less than an ounce and criminal trespass, Mr. Jackson, how do you plead?
I would like to plead no contest, Your Honor.
No, we didn't discuss that. You would have to plead guilty if you take this plea today.
Yes, ma'am. I would like to plead guilty, Your Honor.
All right, I accept your guilty plea at
Thank
this
you.
time, Mr. Jackson. I believe that concludes his case. If there's nothing further from Ms. Soledad or Mr. McLean.
Thank you, Your Honor, nothing more.
All right, best of luck to you, Mr. Jackson. We don't want to see you back here anymore, all right? Take care.
Yes,
All
ma'am.
right. All right, who do we have next?
Position 12, Duncan.
All right, good morning, Mr. Duncan. Your case is 22 CR 007726E. In this case, you're charged with 1 count of theft by shoplifting and 1 count of criminal trespass, each with the offense date of November the 10th of 2022. Do you understand your rights?
Yes, ma'am.
All right, thank you. The announcement that I have is that this is a negotiated plea. Is that still correct, Mr. McLean?
Yes.
All right, Ms. Gillette, please proceed.
Yes, Your Honor. The state's recommendation for theft by shoplifting is 12 months served, 42 days, credit for time served, 21 days, balance probated, theft class, and stay away from the incident location. And for the criminal trespass, time served, let me get the incident location really quickly. And that is Target at 2539 Piedmont Road, Atlanta, Georgia, 30324.
What is he alleged to have taken in this case, Ms. Gillette?
Yes, Your Honor. Toiletries.
All right. Mr. McLean, was that your understanding of the offer? And do you stipulate to the factual basis, ID, and venue?
We do so stipulate, Your Honor. It is our understanding.
All right, please raise your right hand, Mr. Duncan. Are you, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am, I do.
All right, thank you. Put your hand down. Are you under the influence of any drugs, medication, or alcohol at this time?
No, ma'am.
Are you satisfied with Mr. McLean's representation?
Yes, ma'am.
And do you understand that by pleading guilty today, you're giving up your right to a trial by judge or jury?
Yes, ma'am, I do.
And you understand that you'll have no further court dates regarding this particular case where the state would have had to prove the charges against you beyond a reasonable doubt.
Yes, ma'am, I do.
All right, and you understand that you must stay away from that incident location, that Target store, and you're gonna have to take a theft class. You understand that, Mr. Duncan?
Yes, ma'am, I do.
All right, as to the charges of theft by shoplifting and criminal trespass, how do you plead, Mr. Duncan?
Guilty.
I accept your guilty plea at this time. Is there anything further?
Nothing, Your Honor, thank you.
All right, best of luck to you, Mr. Duncan. That concludes your case.
Thank you very much, Your Honor. Have a good one.
Have a great day. All right, who do we have next?
Yeah. Position 13, Gaskin.
All right, good morning, Mr. Gaskin. Your case number is 22 CR 007727C. In this case, you're charged with criminal trespass with the offense date of November the 10th. Do you understand your rights?
Yes, ma'am.
All right, I have that this is a negotiated plea as well.
It is.
All right. Ms. Salette, please proceed. Please give me the state's offer as well as the brief factual basis.
Yes, Your Honor. The state's recommendation for criminal trespass is 12 months served, 44 days, credit for time served, 22 days, balance suspended, stay away from MARTA. And on November 10th, 2022, at 216 Peachtree Street, MARTA, the defendant did knowingly and intentionally enter and remain in a visibly restricted area by walking on the tracks without the consent of MARTA.
All right, thank you. Ms. McLean, was that your understanding of the offer, and do you stipulate the factual basis, ID, and venue in this case?
Yes, Your Honor, it is our understanding and we do so stipulate.
All right, Mr. Gaskin, I'm gonna ask you some questions, just as you've seen me do previously. Can you please raise your right hand? Do you swear and affirm the testimony you give for the limited purposes of taking this plea will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
I'm not.
Has anyone promised you anything in exchange for taking the plea?
No, ma'am.
Has anyone forced you to take a plea?
No, ma'am.
And you understand that by pleading guilty, you're giving up your right to a trial by judge or jury.
Yes, Your Honor.
And you're also giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, Your Honor.
All right, and you understand the requirements of this sentence, that you absolutely cannot go back to that MARTA station. However, the time you've served in Fulton County Jail should close the case otherwise. You understand that?
Yes, ma'am.
All right, as to the charge of criminal trespass, Mr. Gaskin, how do you plead?
Guilty.
I accept your guilty plea at this time. Anything further, Mr. McLean or Ms. Salette?
Nothing, Your Honor. Thank you.
Nothing from the state.
All right, best of luck to you, sir. That concludes your case.
Yeah.
All right, who do we have next?
Position 4, Alizier.
Show it.
All right, good morning. Your case is 22 CR 007724G. In this case, you're charged with theft by taking a misdemeanor with the offense date of November the 18th of 2021. Do you understand your rights?
Yes, ma'am.
All right, and this is a negotiated plea as well, Mr. McLean?
Yes, Your Honor.
All right, Ms. Salette, may I have the state's offer as well as a brief factual basis?
Yes, Your Honor. The state's recommendation is 12 months served, 60 days, credit for time served, 22 days, balance probated, a restitution amount of $220, a theft class, and stay away from the incident location, which is 5475 Windward Parkway, Alpharetta, and that's a BurgerFi, F-I location. On November 19th, 2021, Mr. Alzier, along with the Ali Festa King, stole the victim's cell phone from a BurgerFi restaurant. The victim's name is Maya Thurman. This incident was captured on surveillance video, and Mr. Alzier's co-defendant then sold the phone at a kiosk nearby at a Walmart, where her identification was photographed on that kiosk. And further at this time, Your Honor.
All right. Was that your understanding of the offer, Mr. McLean? To clarify, how many additional days would he have to serve at the Fulton County Jail, Ms. Select?
One moment, Your Honor. I think maybe 8 more days, but I just I want to verify that he actually served 22 days.
All right.
On that very point, may I point out that there is documentation in our paperwork that he came to us from another jail. And at the point in time in which that other county was through with him, this hold for Fulton County's matter would have been the only thing on his booking sheet at even that jail. And it would be fair to give him credit for that time as well. What I don't have is the date of disposition in that county to say whether that should be 5 days, 20 days, 10 days. He asserts to me that it was how many days?
I could only account for the days that he served in Fulton County. I don't know what Fulton County will count as far as from another county.
But even our documentation shows that he's been in continuous custody since August the 16th.
He'd have to still be booked in on that charge, so. If Mr. McLean, if the possibility is that your client would have to serve an additional 8 days, would he still want to take this plea today?
What do you think?
And Your Honor, I just want to put for the record, I'm not opposed to what Mr. McLean is saying. It's my understanding now that I can't just say a number of days. Fulton County it has to.
Right, they do their own calculation, and sometimes you end up with credit as long as it's for the actual charge. We just can't prove that would be the case. So that's my question, Mr. McLean. If he does not get credit for the additional time, and he does in fact have to serve 8 more days to satisfy the requirements, would your client still like to take the plea?
I believe so, Your Honor, because I will make my effort to get the other county to send us a disposition date so we can see how many days he was solely on the other. I can't give any guarantees about the record room giving credit.
All right, so what we're saying is the state of neither the state or the court has any objection to counting the other days. We just can't guarantee that he would get that credit. So we're gonna go forward with the plea. Mr. McLean, do you stipulate to a factual basis, ID and venue?
We do stipulate those 3 elements, yes, Your Honor.
All right, sir, please raise your right hand. I'm gonna place you under oath for the purposes of taking the plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hands down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor, I'm not.
Are you satisfied with Mr. McLean's representation? Did you say yes?
Yes, ma'am.
All right, and you understand by pleading guilty, you're giving up your right to a trial by judge or jury?
Yes, ma'am.
And you're also giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you understand that if you have any other open cases or if you're on probation, that this plea might affect the status of other pending cases?
Yes, ma'am.
All right, as to the charge of theft by taking, how do you plead?
Yes, Your Honor.
All right, at this time, the sentence will be that you are gonna serve 12 months, but you'll see for credit, 12 months to serve 60 days, credit for time served 22 days. You're gonna pay $220 in restitution, attend a theft class, and stay away from that incident location on Windward Parkway in Alpharetta, Georgia. Anything further from either the state or the defense? All right, hearing none. Best of luck to you, sir. That concludes your case at this time. All right, who do we have next?
Your Honor.
Position 5, Blade.
All right, good afternoon. I'm sorry, it's still morning. Good morning. Your case is 22. Good morning. Your case is 22 CR 007866F. In this case, You have 5 particular charges with the offense date of November the 17th of 2022. You're charged with 1 count of, let's see, 1, 2, 3, 4 counts of, oh, I'm sorry, 3 counts of giving false information, 1 count of expired tag or unregistered vehicle. Perhaps it's 4 counts. 1, 2, 3. Yes, 4 counts of expired tag. 4 counts of giving false information to a law enforcement officer and 1 count of expired tag. Do you understand your rights?
Yes, Your Honor.
All right. And my announcement is that this is a negotiated plea. So Ms. Salette, please proceed.
Yes, Your Honor, one moment.
I'd like the state's offer as well as a brief factual basis.
The state's offer for the first count of giving false information to a law enforcement officer is 12 months served, 30 days, credit for time served, 15 days, balance probated, 25 hours community service. For expired tag or unregistered vehicle, 12 months served, 30 days, credit for time served, 15 days, balance probated, $100 fine. For the remaining counts of giving false information to a law enforcement officer, served. On November 17th, 2022, near Old National Highway in Flat Shoals, the defendant was pulled over for an expired tag, and he did give officers a false name, date of birth.
Okay.
And that's the only information I have from the warrant, Your Honor.
All right. Mr. McLean, is that your understanding of the offer? Do you stipulate the factual basis, ID, and venue?
Your Honor, yes, I would like to make one clarification point. That is our understanding of the offer, and we do stipulate to the factual basis, which I will speak to now, as well as the other 2 elements, venue and ID. Well, ID is the point. He wishes to be completely open and honest with everybody. At the time of speaking to the officer, he should not have been driving, and he admits that because he was having high sugar, in other words, diabetes. And when speaking to the officer, there was a little bit of confusion and there was some miscommunication. This man's name is Ebenezer Kokie. Ebenezer, the regular spelling. The last name is spelled Kokie. His date of birth is well, I'm not going to state that over the thing. Sorry. He didn't mean intentionally to give false information, but he and I have discussed the pros and cons of going before a trier of fact and presenting evidence and having a beyond a reasonable doubt proof standard. And he has made the decision he wishes to go ahead with this offered plea as a negotiated plea today. And I understand the factors because there are family reasons why he needs to get back to his family ASAP. So I'm not going to stand in the way of his doing a negotiated plea, although I'd rather try the case. But he asked me to put up a negotiated plea, but he wanted me to state to the court that that is his name, Ebenezer Kokie.
So, Mr. McLean, it sounds like he contests the charge and that this case should go to trial. Is that what you're saying, Mr. McLean? Are you saying that?
I'm saying that I, as his attorney, I would be more comfortable going to trial, but he is not. He is not comfortable with going to trial. He feels that he has sufficient jury risk to offer a negotiated plea on this, and he is satisfied with the negotiation.
Okay.
He's asking the court to accept the plea as the state.
I'm just listening, Ms. McLean. If he's saying that he didn't give the false information,
Oh,
are you saying that he did?
he doesn't much know what he said at that time. Lord knows what he would have said, but he says, my actual name is this, whatever name I was giving, this is my name. That's his point.
Okay, understood. All right, we'll take the plea based upon the information presented by Mr. McLean. Sir, please state your name for the record.
Ebenezer Kokie.
Okay, so the name that he's booked in as, Mr. McLean, is not his, what name is this? That's not his correct name?
He says that's the person whose car it was, his friend's car. And so the officer finally concluded, this is you. So I'm putting your name down. So this is just an administrative matter. He is under the incorrect name, but
So he's booked in under this name, Baldy or Bald, and you're saying that that is not his name at all?
right.
So
That's-
essentially, this person whose car it is will end up with this charge.
It would be better to cast the accusation under the correct name.
Hold one moment for me.
But in the long run, I really appreciate you.
Ms. McLean, I don't think we can take this plea today. What will happen is if the defendant is booked in under a different name, what will happen is the person whose name is actually appearing on the sheet will,
I've seen the state re-accuse, Your Honor, within minutes. They could, if we could just.
Your Honor, I'm going to reaccuse the case with the name. We don't have any
your
verification.
phone froze for a second, Ms. Olet. I'm sorry, what did you say?
I was just saying, on behalf of the state, I'm not going to be reaccusing this case today based on the defense attorney saying that that's what his name is. I would need more documentation than that. Like, was he not fingerprinted in? I think this just opens up another.
Okay. So what we're gonna do is we're not gonna take this plea today and there's too many identity issues surrounding this plea. And I think what needs to happen from here is, Ms. McLean, I'm gonna reset this case till next week, Thursday. If you can.
Could we make it even quicker, Your Honor?
I'm sorry?
Could we make it even quicker?
If you're able to get information regarding his name, perhaps the state would consider recusing it, or we should reset it for trial, as identity is one of the key issues and factors at trial, for lack of a better word. So we can't let him take a plea to an accusation with a name that's not his. So we would need some information regarding the actual identity. I don't know that setting it for Tuesday will give you enough time to give that information to the state. Will it give you enough time, Mr. McLean?
We will certainly try. It's no different between Tuesday and Thursday for me, because on Wednesday and Thursday of next week, we have court on Tuesdays and Thursdays, and Friday's our only day to get anything done anyway.
Okay, so we will reset this case to December the 6th. SAP calendar in the hopes that the defense will provide some information regarding the defendant's identity. Should that not happen, I believe that the case will need to be arraigned and reset further notice to a division judge, whereby we could, the issue of identity could be further explored.
Right.
Does the state wish to be, I'm sorry, does the defense wish to arraign this case today and be heard on bond?
We really would like to be heard on bond. Yes, Your Honor.
All right, so that's what we'll do. I'm gonna formally, or will you enter a written waiver of arraignment, Mr. McLean?
Well, we can waive the reading of the accusation, but ultimately it's going to be under the wrong name anyway, because that's the important point.
That's true. That part is correct.
It would be pointless.
So we'll still reset it to Tuesday. We'll hold a bond hearing at this time. Ms. Jackson, may I please have his history now that we're gonna revisit his bond?
The defendant has 17 cycles. The defendant's last arrest was May the 13th, 2021, with the City of Atlanta Police Department for driving while license suspended or revoked. There was no disposition for that arrest. The defendant does appear to be on probation in DeKalb County for aggravated battery. That disposition date was December the 5th, 2019, and the term is for 3 years and 6 months. Also, the defendant appeared to have an outstanding hold out of Pennsylvania for a probation violation. The date on that warrant is November the 1st, 2021. In addition to that, the defendant has a hold out of Decatur, Georgia for a probation violation. The date on that warrant is February the 15th, 2022. The defendant does have a history of probation violations. There's one in 2017, one in 2018, one in 2019, and one in 2021. And the defendant does have prior misdemeanor convictions. It's one in 2021 for simple assault, one in 2016 for driving while license suspended or revoked, one in 2015 for driving without a valid license, and another one in 2015 for disorderly conduct. Nothing in addition, Your Honor.
Your Honor, may I have just a moment?
Yeah. Very briefly.
So do we have that correct name on that 17 cycle thing? Let me get back off of you.
Clearly we're running the name that appears on the booking sheet, not the
Right.
allegation of another name. We're
Very
gonna go with the name that appears on the GCIC and that he's booked in as right now. I understand that there's an identity issue, but this is the name that we have
Right.
and the bond that he would be able to get out up under. All right, Ms. Salat, please proceed with the state's position on bonds. I actually set this bond. So if you would just briefly remind me of the facts of this case. You already pretty much have.
Yes, Your Honor. The state is going to be asking that you keep the bond that you set in place, the $1,250 surety bond. I mean, at this point, we're not even sure what this person's real name is. So I don't know how we would be able to contact them to make sure that they're present for court. I think he posed the risk of being a risk. And based on the history that pretrial read today, just based on the name and date of birth we have today, he does have a lengthy history and poses a risk of reoffending. Nothing further from the state at this time.
All right, and just to clarify, it's a $1,250 split bond. I think that count two is a SOB through the jail for the registration. So he's only being held on 1,000 surety. All right, Mr.
Thank
McLean.
you.
And Your Honor, he says his child is sick and staying with the aunt in Fairburn. And he's anxious to go see his child. Thank you.
All right, bond will remain as set. At this time, we'll reset him to the December 6th SAP calendar in the hopes that we get some information clarifying his identity. Should we not be able to clarify identity on December 6th, I believe the case should be arraigned at that time and reset for the notice to a division judge whereby an identity could be proven at trial or by motion.
Thank you, Your Honor.
All right, best of luck to you, sir. Could we have next?
Position 15 and 16, Houston.
All right. All right, so 15 is an FTA charge. So really, is 15 and 16 the same person?
Yes,
It's different spelling on the names.
Yes, we checked on that. It is.
All right. So you, sir, you're here essentially for case 22 CR 006249H, in which you're charged with one count of theft by shoplifting, one count of willful obstruction of a law enforcement officer, and one count of crossing a pedestrian road diagonally with the offense date of September the 15th of 2022. You also have an FTA from November the 2nd, where you failed to appear for a fingerprintable charge. All right, so the announcement I have for position 16 is that this is a negotiated plea.
It is.
All right, Ms. Salet, will you please give me the state's offer as well as a brief factual basis?
Yes, Your Honor. for theft by shoplifting, 12 months served, 24 days, credit for time served, 12 days, balance probated. Theft class, stay away from the incident location, which is a Target at 13055 Highway 9 in Milton. For the obstruction charge, 12 months served, 24 days, credit for time served, 12 days, balance probated, $300 fine. And for the pedestrian crossing road diagonally, time served, and that is to all run concurrent, Your Honor. On September 15th, 2022, officers were dispatched to that Target location in Milton, and they met with the loss prevention officer who witnessed the defendant on surveillance video taking a Roomba vacuum that was priced at $499, and he passed all points of sale. Upon officer arrival, the defendant did flee after receiving multiple commands to stop. He disobeyed those commands. The defendant also crossed Deerfield Parkway in Milton on foot during the pursuit. The defendant also admitted to stealing the merchandise. Nothing further from the state at this time.
All right, Mr. McLean, do you stipulate to the factual basis, ID and venue?
We do so stipulate, and we have heard our understanding of the terms.
All right, thank you. Mr. Houston, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah.
All right, put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Did anyone promise you anything in exchange for taking a plea?
No.
Did anyone force you to take a plea today?
No.
Are you satisfied with Mr. McLean's representation?
No.
Did you say yes? Are you satisfied with your attorney's representation?
Yeah.
Do you understand by taking a plea, you're giving up your right to a trial by judge or jury?
Yes.
And you're giving up your right to have a state prove these charges against you beyond a reasonable doubt? And you understand you'll have to pay a $300 fine, and you'll also have to complete a theft class as part of your probation, but you should not have additional time to serve at the Fulton County Jail. You understand that?
Yes, yes.
All right, as to the charges I previously listed, how do you plead, Mr. Houston?
Yes.
I accept your guilty plea at this time. I believe that will conclude your case if there's nothing further from either party.
Your Honor, on case 15, there is a notation of sending it back to the courtroom judge.
Right, I think what I've been told is that the state needs to present us a null pros for that case.
Right, thank you.
All right. All right, that concludes Mr. Houston's case. Is there anything further? All right, hearing none, best of luck to you, sir. All right, who do we have next?
Position 10, Carter.
All right, good morning, Mr. Carter. Your case is 20 CR 003640Y. In this case, you're charged with battery family violence with the offense date of June 6th of 2020. Do you understand your rights?
Yes, yes, ma'am.
All right, I have that this is a negotiated plea. Is that still correct?
It is.
All right, Ms. Gillette, please proceed.
Yes, Your Honor, one moment. So the state's recommendation is 12 months served, 136 days, credit for time served, 68 days, balance probated, 24-week family violence intervention program, and no contact with the victim. If you just give me one moment to pull up the report on this case.
And what, does that require additional jail time, Ms. Gillette?
No additional jail time, Your Honor.
All right, thank you for that point of clarification.
And that victim's name is Stephanie Judon, Judon. On June 6, 2020, Officer Holmes with the Atlanta Police Department was dispatched to 732 Quaker Street. Upon arrival, he met with the victim, Ms. Judon, who stated that she and the defendant were arguing. And they began to argue about her cell phone. The defendant got upset and started punching her in the face and eventually slamming her head onto the floor. Officers observed a bloody lip and a large knot on the back of the victim's head as a result of the incident.
All right, thank you. Mr. McLean, do you stipulate to factual basis, ID, and venue? Was that your understanding of the offer?
It is our understanding of the offer, and we do so stipulate to those three elements.
All right, Mr. Carter, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs, medication, or alcohol at this time that would affect your ability to understand this proceeding?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
And you understand that by taking a plea today, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're prepared to waive your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you offer this guilty plea freely and voluntarily with an understanding of the charges against you?
Yes, ma'am.
As to the charge of battery family violence, Mr. Carter, how do you plead?
Guilty.
I accept your guilty plea. The sentence will be 12 months to serve 136 days, credit for time served 68 days, with the balance probated. You're going to attend a 24-week family violence intervention program, and you will have no contact with the victim. Is there anything further from either party?
Yes, Your Honor, at the rate of $35 per hour for the FVIP or per week, it's going to cost them either $840 or $1,040 if there is a $200 application fee. And we would ask the court to give them a financial break by waiving probation fees for the first 6 months.
All right, we will waive 6 months of fees.
Thank you.
All right, best of luck to you, sir. I believe that concludes your case.
All right, thank you, ma'am.
All right, who do we have next?
Hello, good morning. Morning.
Okay, sir, please hold. All right.
Okay.
All right, who do we have next?
Position number 3.
All right. All right, do we have an interpreter on the line? Does your client requires an interpreter, Mr. McLean?
He does. We've tried. He does have a tiny amount of English, and so we really do need the interpreter. I think with this case.
Have you been able to speak to him?
I did speak with him a little bit, but it's really not sufficient to really convey all the concepts.
All right. Mr. Jordan or Ms. Lewis, will we have an interpreter today?
We don't have one currently, Judge, but I can get one if we need one.
All right, we're gonna try to get one. We'll have to come back to position 3 or on hold for interpreter.
Very good.
Position number 14, Mr. Glenn.
And that's the one where I need to let him know.
Oh, that's the one you need to speak to him.
Right.
So
I can run up to 4 and run back.
all right, have you completed all the cases that you would need to complete down there, Mr. McLean?
All right, let's see. I think we're going.
Position 9 says set for MH calendar.
Yes, that's correct.
So is position 9 there today? Because that position is not appearing on today's MH calendar.
It's not.
I thought I saw in Odyssey that that calendar was scheduled for 10 a.m. today.
Right, but Ms. Champion says she does not see that person's name. She's gonna check.
That is for, tree, that was where that's hurt, Kurt.
Okay, so for this particular charge, he's not scheduled for it. So position 9 for this particular charge ending in 7872A, he has not been assigned to that particular court. He's not been assigned to mental health court. So is there another announcement for what needs, are you asking that it be taken to mental health court? Because it's not currently there.
That it was.
We're gonna verify what happened to position 9 before you go up to 4 South.
Oh, Your Honor, I don't have to go up to floor now because they have done the great task of bringing him down to our courtroom. Mr. Glenn is here. I'll consult with him in what we refer to as the red.
Okay, why don't you consult with him while we figure out what happened to position 9?
Thank you.
And also, what about position 28? We haven't heard that position either.
It's fine. Are you sure? I was glad with that. That is whatever.
All right, position 9 was seen today, so he should not appear on this calendar. And there's no further disposition for this court, for this particular
Judge
hearing.
Williams? Hi, this is Natasha Crawford from the Solicitor's Office. Regarding Ronald Brown, 22 CR 007-872A, he has been accepted into mental health court.
Right, we just got that announcement, so yes. So
Thank you.
yes, he should not have been on here. Is there an announcement for position 28? Or will we still be taking that position there, Mr. McLean? Oh, Mr. McLean is muted. Anthony Smith, is he in that courtroom or will we be going to that position?
That would be with Ms. Helen.
That'll be Miss Helen.
Oh, that's Ms. Helen's client. All right.
Your Honor, also a new announcement, number 14 is negotiated plea.
All right.
Thank you.
Thank you. All right, Mr. Glenn, the case is 20 CR 007733J. In this case, you're charged with 1 count of willful obstruction of a law enforcement officer with the offense date of, and 1 count of battery family violence with the offense date of November the 10th of 2022. Do you understand your rights?
Yes, ma'am.
All right, Mr. Lett, if I could have the factual basis, and as well as the state's offer.
Yes, Your Honor. For the obstruction charge, 12 months served, 90 days, credit for time served, 22 days, balance probated, $300 fine. For the battery family violence, 12 months served, 90 days, credit for time served, 22 days, balance probated, 24-week family violence intervention program, no contact with the victim and to stay away from the incident location. And as far as factual basis, oh, I'm sorry, let me give you the victim's name. Shakeela Lindsay, and that's SHAKEELA, Lindsay, LINDSEY. And you can, I guess the state will retract this statement about staying away from the incident location, whereas this incident happened on a public road. On November 10th, 2022, officers were dispatched to Racetrack gas station located at 1180 Virginia Avenue in reference to an assault. Upon arrival, they met with the victim, Miss Lindsay. She advised that her boyfriend at the time, the defendant, they were arguing on Virginia Avenue in Hapeville when the defendant pushed her into the bushes and started slamming her body on the ground. He grabbed her by the leg. She tried to get away and he grabbed her back into the bushes and started to punch her in the face multiple times, causing bruising and swelling to her left eye. Officers were able to get a photo of her injuries to her eye. The defendant, the victim made officers aware that the defendant was back at their hotel room. And so the officers went to the hotel room to try to arrest the defendant. He would not open the door. They were eventually able to arrest him at that time on that date. The defendant does have some prior history out of New York, showing a 2016 second-degree assault conviction and a 2015 violation of order of protection conviction as well out of New York. He does have some other convictions, but those are the ones that are relevant to the violent nature of this case, Your Honor.
All right, thank you. Mr. McLean, was that your understanding of the offer? And do you stipulate the factual basis, ID, and venue in this case?
It is, and we do.
All right, thank you. Mr. Glenn, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Has anyone promised you anything in exchange for taking a plea?
No, ma'am.
Has anyone forced you to take a plea?
No, ma'am.
And do you understand that by taking the plea, you're giving up your right to a trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you're offering this guilty plea freely and voluntarily with a full understanding of the charges and the requirements?
Yes, ma'am.
And to clarify those requirements, I do not believe you'll have additional time to serve. Well, let me clarify that. Is there additional jail time? How much additional jail time is there?
23 more days.
All
That's
right,
correct, Your Honor.
all right. And you will have 23 more days to serve at the Fulton County Jail. Upon your release, you'll need to pay a $300 fine and you'll be on probation. You'll also complete a 24-week anger management course and have no contact with Ms. Lindsay. Do you understand all of that, Mr. Glenn?
I wasn't aware of probation.
Yes, we discussed the probation extensively, as a matter of fact. The $49 fee on probation, Your Honor, since he's going to do an FVIP, which is roughly in the neighborhood of $1,000, we would ask the court to waive 6 months of probation fees so that he can do that. And hopefully that once he does complete the FVIP, he will maybe go to non-reporting where there won't be a charge for that as well. Your Honor, he will be going to New York next, so he and I discussed that FVIP is a national concept that has certain standards, and if you'll just check with JCS.
Okay, so, but before we go to that, do you want to still take the plea? You will be on probation, Mr. Glenn. If you're pleading guilty today, that you will be required to be on probation and report. It does not sound like Mr. Glenn wants to take this plea today.
I do want to take the plea. I just want to know how long I'll be on probation. 90 days?
The probation.
No, your probation will run for a whole year.
Right. But I'm asking the court to consider dropping fees on it so that you can report back home from New York, do your FDIP in New York, and you'll be fine. Okay.
Do you wish to take the plea, Mr. Glenn? You're gonna be on probation the whole time.
Yes, ma'am.
And due to the nature of the offense, I will waive 6 months of fees, but I'm gonna require that you report the full year. Do you still want to take this plea? All right. As to the charge of willful obstruction and battery family violence, Mr. Glenn, how do you plead? I accept your guilty plea. I waive 6 months of fees. Is there anything further that needs to be addressed by either the state or the defense at this time?
Nothing.
From the state.
All right, best of luck to you, Mr. Glenn. All right, who do we have next? Our position 28 should be the remaining, I believe the only case that remains on state on purpose.
Take this piece.
We do have the interpreter case, Your Honor, if we're able to get an interpreter, but.
Yeah, that's position.
We're still holding for that. I didn't forget that one.
Okay.
The cases we don't have an interpreter yet, so can we take position 28 and hope that we get an interpreter? And then what we'll do is after 28, we'll go do the DV reset and then we'll review the calendar. And hopefully by that time we'll have interpretation.
Where's Derek? Where's Derek? He's up there.
Here, you have it.
Everybody's done. You did all your cases?
Except for the Spanish speaking guy.
All right, Judge, we're completed, in courtroom 2 for right now.
Okay, position 28 is not there.
Let me see who that is.
Anthony Smith. And there's no people from the competency calendar on position, in courtroom 2 either.
Yeah, we do have a competency, position 10, Mr. Johnson.
Okay, well, we can't quite yet go to that. I was just curious as to whether competency people were there. But position 28, there's no announcement?
That's a negotiated plea, Judge.
Right, but is the defendant there?
No,
Ms.
Judge.
Anthony.
I don't believe he is, Judge.
Okay. Will he be brought or is he in medical or?
He's upstairs.
Anthony is on the board. Ms. Anthony?
You're not here.
Okay. Are we going to get him? Should we hold and I do the DV reset in the meantime?
We'll get him, Judge. Mr. Smith.
All right, thank you. I appreciate that. And is Mr. Jordan any luck with interpretation? Or will we need to reset that case? All right, April, will you check for me? Thank you. We're gonna do the DV bench warrant case. Is Mr. Terrence Goss on the line? Was that who was on iPhone earlier?
Yes, I'm here. Mr.
All right,
Goss.
Mr. Goss, are you driving?
No, ma'am, I'm not. I'm currently working.
You're what?
I'm currently working.
Right, but are you driving?
No, ma'am, I'm not. I'm not.
Are you riding in a vehicle?
I'm driving in the truck. Yes, ma'am. Company truck.
Right, but you're not the one operating the vehicle, correct?
No, ma'am, I'm not. So I'm obligated to talk.
Okay. All right. Who represents Mr. Goss? Did you have a public defender, Mr. Goss?
Yes, ma'am, I do that for
Okay.
Mr. McLean, Michael.
Mr. McLean, you represent Mr. Goss?
Yes, yes, Your Honor.
All right, Mr. Goss, I'm gonna explain your rights. This is case 21 CR 001414E. In this case, you're charged with simple battery family violence with the offense date of March 31st of 2020. I believe that this case is on this calendar, the DV bench warrant case, because there's a bench warrant out for your arrest whereby you failed to appear in court. What we're gonna do today is we're gonna listen to ascertain whether the bench warrant will be lifted or whether you'll be required to surrender yourself at some point to the Fulton County Jail. What we'll also discuss is whether or not there's a plea offer that you might want to take at this time. Ms. Duncan, is this your case?
It is, Your Honor.
Is there a plea offer at this time?
At this time, there is no plea offer.
There's no plea offer from the state. All right, it was my hope that there would be one so that perhaps we could resolve this aging case. Is there, have you had a chance to perhaps discuss this case with a supervisory member of the solicitor's office, such that a plea could perhaps be presented at this calendar today?
We have not discussed a plea. However, we do have an argument prepared for this case before Your Honor.
I understand that, but I was hoping that the state would consider resolving this. This is a 2-year-old case and the defendant is currently out. All right, we will hear arguments regarding bench warrant. Please proceed, Ms. Duncan.
Yes, Your Honor. This defendant is out on the bench warrant. He has TA for plea and arraignment back on June 14, 2021. This defendant also FTA for jury trial on November 7, 2022 before George Morrison. At that time, the defendant had already had one bond forfeiture set aside for that FTA for the jury trial. And then there was a jury trial set for back in August 25th of 2021. The defendant did not appear for that. There was an additional address change and a set aside. The address was changed to a Dodson Road address. There was a return to sender, and on October 31st, the defendant in this case did change their address. And then there was another bond forfeiture set aside because the defendant continued to fail to appear. So we have what I believe is 2 set asides and at least a failure to appear twice, once for plea and arraignment and once for a jury trial. So it's my understanding that this defendant is apparently looking to ascertain a jury trial for these charges at this time. That's why no plea was discussed. However, since this defendant has continued to fail to appear in this case on several occasions, the state believes it's appropriate at this time that the bench warrant not be set aside and that the defendant be remanded into custody.
So there was a change in address, such that, and a return to sender. So there was, so even though he failed to appear once, he didn't receive the notice of the jury trial, or he didn't receive the notice. I'm trying to figure out which notice was returned, Ms. Duncan. Do you know?
So what, from what I gather, what happened, Your Honor, is that there was plea and arraignment. And he failed to appear for that plea and arraignment, changed the address at that time after failing to appear. Then it was set for jury trial. However, it didn't appear for jury trial before George Morrison, and they sent it to that address that he had changed for that plea and arraignment. I did not see an RTS for that one, but there was a set aside, but I didn't see another address added to the record. There was also a bond forfeiture hearing, a Rule Nisi hearing, and there was no additional address on that. So it's been 2 bond forfeitures at this point and 2 FTAs for plea and arraignment and jury trial.
Okay. Mr. McLean?
Your Honor, the perspective I was trying to figure out from this case is the primary thing was 1.5 years ago. It was basically June 14th of 2021. And that's the date that he missed the plea and arraignment. So August, or let's see if I can look at that for just a second. June 14th, 2021 was plea and arraignment. Then it says that he had something on August the 25th of 21, which is the same summer over 1 year ago. What I would want to look at is the more recent stuff. And I said to him, you know, it doesn't look good because you changed your address. And the point the court wants to know is, are you trying to duck court or not? And he says, no, sincerely, I'm not trying to duck court. He says, you know, I'm just the address did sincerely and legitimately change. And we had a heart discussion about how if you'll just check with the Fulton Daily Report or go to the clerk's office, those two methods will ensure that the post office is not perfect. Sometimes you miss your mail. That's going to happen. And so he understands checking the Fulton Daily Report. He understands how to check it on the internet. He understands how to go to a library and check it. And he understands that it is his responsibility always to keep his current address on file. And he says, I've been trying to do that. He is remorseful about all the screw ups.
So what do you suggest or propose, Mr. McLean, at this point?
I would ask to set it aside again, Your Honor, and if there is an offer, I would certainly be conveying it to the client.
Okay. And I want to check one thing myself about what is his current address, Mr. McLean?
The last current address I think on there was that Fox Run. Is that correct, Mr. Goss? Mr. Goss?
Mr. McLean, I discussed it that it's 104 Dogwood, where me and my wife are located at.
Okay, if I can consult on that Odyssey sheet. When you click on the Odyssey by the party, when you go to the parties under case manager, and you click on the actual address, there's an arrow, a little.
So we still don't have a current address for this defendant, is what it sounds like.
Yes.
No, I think the
Okay. All right.
Dawson address is there, Your Honor.
All right, I'm gonna give defendant, I'm not gonna set aside the bench warrant at this time. Defendant is gonna have to surrender himself within 7 days to the Fulton County Jail. He can make arrangements to bond himself back out. Does the original bond get reactivated? That's another part that I never really could figure out. Or does it double? I don't want his bond to double. I wanted the original bond.
He has $1,000 surety.
All right, so he can what sometimes I've seen it happen is that'll turn into a 2,000 surety, and I don't want that to happen. So I'd like him to be able to surrender himself to the jail and bond out on the original surety bond. All right.
And to clarify, did Your Honor state serve 7 days?
Yes, I'm giving him 7 days to do so.
Oh, 7 days to surrender or 7 days to serve?
7 days to surrender himself,
Okay.
and then he can bond himself back out. So he can make arrangements to secure that bond for his release. All right.
Mr. Goss, do you understand the procedure here?
I don't understand. I would like for it to be explained.
Within the next 7 days, go to the jail to be fingerprinted. Arrange in advance for your $1,000 bond. They will fingerprint you, photograph you, and process you right out if you do that.
All right, is there anything further? Mr. Goss, please give Mr. McLean a call. He can walk you through it in more detail. All right?
Okay, sounds good. Thanks.
Otherwise, you're free to go. All right.
Thank you.
All right. All right, do we have either the interpreter or the position? All right, we should have interpretation in 5 minutes, so we'll be on a brief hold for that. And that's the position 28. Is there any announcement?
Officer Norris is still bringing him. It looks like
Okay.
Gulfport's iPhone about to come on.
Okay, wonderful. Thank you.
Hey, McDuffie, who do you have? McDuffie. You're muted.
Hold on. I'm trying to fix it. Hold on. I got it. Mr. Rose, position 17 on the composite calendar.
Oh, before we get to the I don't think we're quite ready for that yet.
Okay.
Do we have position 28 yet, Anthony Smith?
Yes, Judge, we have him right here, Mr. Smith.
All right, thank you.
And Your Honor, before we start that, I just want to clarify for the
Have a seat over
UV
here.
calendar, the 7 days, is that calendared or business days?
Calendar days.
Thank you.
They ain't ready for the.
All right, Mr. Smith.
Mr. Smith,
All right, good morning, Mr. Smith. Your case number is 22 CR 007731C. In this case, you're charged with criminal
They're
trespass.
gonna
with
do
the
it for her and we'll come back with you. All right.
Oh, please mute. With, in that case, you're charged with criminal trespass with the offense date of. Can we mute the jail court iPhone, please? Thank you. In this case, you're charged with criminal trespass with the offense date of November the 10th of 2022. Do you understand? Oh, you have a right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney here today, and Ms. Helen is here to represent you. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this proceeding. Do you understand all of that, Mr. Smith?
Yes, ma'am.
All right, I have that this is a negotiated plea.
That is correct, Judge.
All right, Ms. Duncan, will you please proceed?
Yes, the state's offer in this case ending in 731C is 12 months to serve, 42 days. Balance suspended. Stay away from 688 Gordon Place Southwest. No further contact with Angela Page. That's Angela, common spelling. Page, Paige. According to my research, this defendant has served 22 days as of today. So this offer would be consistent with no further jail time. In this case, Your Honor, on November 10th, 2022, officers responded to the location as stated on the record for a criminal trespass call. They encountered the victim, Angela Page, and she stated to officers that when she arrived home in her SUV, the defendant in this case was inside of her BMW 325i that was parked in front of her residence. She advised officers that he was in fact still in the vehicle, even though she had returned home in her other vehicle. Officers were able to observe the defendant inside of the vehicle and gave loud verbal commands for the defendant to get out. And apparently at first he was ducking down and trying to hide, but eventually he was able to be apprehended from inside of the vehicle and placed into custody and taken to the Fulton County Jail. That is the basis for the state's recommendation in this case.
All right, thank you, Ms. Duncan. Ms. Helen, was that your understanding of the offer? And do you stipulate the factual basis, ID, and venue?
Yes, Judge, that is our understanding of the offer. It's a time served, no probation plea. And Mr. Smith does accept that. And we do stipulate to the factual basis, venue, and ID.
All right, Mr. Smith, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor. Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am, Your Honor.
Are you satisfied with Ms. Helen's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am, Judge.
Did anyone force you to take a plea?
No, ma'am, Judge.
And you understand you're giving up your right to a trial by judge or jury?
Yes, ma'am, Judge.
And you're also giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that you should not have additional jail time, but you must stay away from the address on Gordon Place, and you can have no contact with Ms. Page. You understand that?
Yes, ma'am, Judge.
All right, as to the charge of criminal trespass, Mr. Smith, how do you plead?
Guilty.
I accept your guilty plea. That should conclude your case, all right? Best of luck to you, sir.
Thank you so much, Judge.
All right, thank you. Hopefully interpretation is on the line. And we can go ahead and do position 3. Not yet on the line. All right. Who will be handling the competency calendar today?
Good afternoon, Judge Natasha Crawford on behalf of the state.
All right, you'll be covering, and is Mr. Howard on the line yet?
He's not here at this moment yet, Judge.
Okay, we'll be on hold, so we can't quite do the competency calendar either. All right, we'll be on hold until we're able to get interpretation. Let's give that a few moments. And we'll also hold for Mr. Howard. Thank you. You want to review the calendar? We can review the calendar. That's a good idea. Ms. Champion will review state all purpose with the exception of the interpretation calendar position. I'm gonna move the mic a little bit closer. Ms. Champion's gonna do her best. She's working with the horse through.
Position number 1 is going to be reset SAP 12A. Position number 2 is reset further notice defendant release. Position number 3 will hold it. Position number 4 was a plea. Position number 5 is reset SAP 12C. Position number 6 was transferred to Superior Court. Position number 7 is reset SAP 12C. Position number 8, reset further notice defendant release. Position number 9 is in the MH court. Position number 10 was a plea. Position number 11 is transferred to Superior Court. Position number 13 was a plea. 12 and 13 was a plea. Position number 14 was a plea. Position number 15 was Snow Cross. Position number 16 was a plea. 17 was a plea. Position number 18, reset further notice jail term. Position number 19, that was a plea. Position 20, reset further notice defendant release. Position 21 was a plea. 22 was a plea. 23 was a plea. 24, reset further notice defendant release. Position number 25 was a plea. 26 was a plea. 27 was reset further notice defendant O'Brien with the $1,500 good bond. Position 28 was a plea. 29, transfer to Superior Court. Position number 30, reset further notice of right. Position number 31, reset further notice of defendant release. 32, reset further notice of defendant release. Position 33 was reset further notice jail jury or right with that $3,000 good fund. Any questions?
No, but we're at the jail, Ms. Champion, so we're gonna try to scan and email those documents to you from here, but the bond modification, I'll have to get to you as soon as I can get to a computer.
Okay.
All right, interpretation on the line yet? Or Mr. Howard?
Okay.
Neither party is present.
Can Ms. Helen or Ms. McLean contact Mr. Howard?
Can Ms. That's a great idea. Thank you, Ms. Champion. Ms. Howard, Mr. McLean, will you, is Mr. Howard gonna be joining us in the jail?
Yes, we're all in the jail, so I'll just have to ask the jailers where he is. I don't believe he has a phone on, so.
All right, wonderful. We'll be on a very brief hold. Those who are only joining us for state of purpose, you are free to go. State of purpose is concluded. We are still holding for that interpretation case. So let's give it a few more moments. Thank you all for your patience.
Hi, Judge Williams, are you still there?
I am. Hello, Mr. Walker.
I'm under the weather, but I'm making a special appearance with the case that we have with Miss Boykin. If she's on the line, do you mind maybe going into a breakout with her? I mean, in Deputy Crawford?
I was sedulously trying to do all of those at one time, but
Okay, I'll hold on.
give us maybe 2 minutes, because I'm afraid the minute we'll get in there, the interpreter
You'll come.
They were supposed to be online in 5 minutes. Let's give it a few more minutes and then
Okay.
see that way. Thank you, Mr. Walker.
All right, thank you, Judge.
Hey, Judge. Hey, Mr. Walker.
Hey, Attorney Boykin.
Judge, the interpreter is coming on now.
Wonderful. That was what I was afraid of happening, and I'm glad that we gave it a moment or two. So, Mr. McLean, when the interpreter comes on the line, you'll need to use the interpretation services to speak with your client, correct? You're muted. They're in courtroom too. Good morning, Miss Lucia. Good to see you. I'm gonna swear you in a second. Mr. McLean, would you need her services in order to be able to interpret? In order to be able to speak with, you're still muted. Are you able to unmute at courtroom two?
If I press the space bar, I'm temporarily unmuted.
All right, there we are. Mr. McLean, do you need this interpretation in order to be able to speak with your client?
I did.
Now, I don't know how we're gonna do that, unless we can put courtroom two in a breakout with the interpreter. Is that possible?
Yes, I can, Judge.
All right, before we do that, Miss Lucia, will you please state your name for the record?
It's Lucia Urtusastegui. That's URTUSASTEGUI.
Will you please raise your right hand? Madam Interpreter, do you swear today that you will make an accurate translation from English to Spanish, Spanish to English, according to the best of your skills, knowledge, and ability?
I do, Your Honor.
All right, thank you. We're gonna put them in a breakout, and when they return, we'll be able to go straight into that case. In the meantime, I will go into the breakout with ASG Walker and Ms. Boykin while Mr. McLean speaks with his client.
And can we include Deputy Crawford as well, please, Judge?
Yes, and if we could ask this gentleman that's in the courtroom to please just step out for one moment, sir. I know you're here for your brother, but this is confidential proceeding. Once we finish, you can come back in, all right? Thank you for your patience.
Your
And
Honor,
is Mr. Howard coming as well? No update on Mr. Howard.
Your Honor, before you go into the breakout room, my business is concluded. May I be excused?
Yes, you can.
Thank you.
All right.
And who all you need to be in the breakout room with, Judge? Sorry, I was on the
It's
phone.
me, Mr. Walker, Ms. Crawford, and Ms. Boykin.
Hey, Judge, we're ready on that translation case.
I think she's in a breakout room.
All right, we're gonna take the plea in the case of Mr. Joel Alvarez Romero. Madam Interpreter, are you still on the line? Miss Lucia?
Yes, Your Honor, yes.
All right,
Yes,
wonderful.
I'm here.
All right, Miss, you're still under oath. Joel Alvarez Romero, good morning.
Señor Joel Álvarez Romero, buenos días.
I'm Judge Melanie Williams,
Yo soy la juez Melanie Williams
and this is the state all-purpose calendar in Fulton County, Georgia.
y este es el calendario de cargos y negociaciones del condado de Fulton en Georgia.
Your case is 22 CR 00 7424H.
Este es el caso 22 CR 007424H.
In this case, you're charged with one count of discharge of a firearm on or near a public highway or street.
En estas acusaciones tiene una acusación por descargar y cargar una arma de fuego cerca de una calle pública.
One count of reckless conduct.
Tiene una acusación, un cargo de conducta peligrosa.
And one count of carrying a weapon or long gun in unauthorized locations.
Y una acusación de tener consigo un arma o una pistola larga en un lugar que no es autorizado.
You have a right to remain silent. Anything you say can and will be used against you.
Usted tiene el derecho de permanecer en silencio. Cualquier cosa que usted diga puede y será usado en contra suya.
You have a right to an attorney. And okay,
go ahead, Your Honor. I'm sorry. Go ahead.
You have a right to an attorney, and Mr. McLean is there to represent you.
tiene el derecho a tener un abogado y el señor McLean está al lado suyo representándolo.
This proceeding is being broadcast over the internet as a live stream. It's also being recorded.
Esta audiencia está siendo grabada y también está siendo exhibida por medio de internet en la red.
That means any member of the public can log on and watch this proceeding.
Lo que eso significa es que cualquier miembro del público puede tener accesar y ver este proceso.
Do you understand your rights?
¿Comprende usted sus derechos?
Can we unmute so we can understand, we can understand if he knows? So we can determine whether he understands. Do you understand your rights, sir?
¿Comprende, señor, usted sus derechos?
Sí.
Yes.
All right. What is your announcement, Mr. McLean?
This should be an arraignment, Your Honor. We waived the reading of the accusations. We have copies of them, and we will discuss it further. We ask to go to jail jury for the notice. Bond is moot.
Lo que la juez le pide al abogado que diga es la posición. Entonces, ellos ahorita están renunciando a que se le lean los cargos porque ustedes tienen una copia y también se pide que se fije una fecha para el juicio.
Why is bond moot, Mr. McLean?
Your Honor, he has a hold. We've discussed.
Y la juez pregunta por qué no darle una fianza y su abogado indica que porque tiene usted esa detención por inmigración.
All right, Mr. Alvarez Romero, I'm going to formally arraign your case.
Señor Álvarez Romero, yo voy a formalmente presentar su caso.
That means I'm going to explain the charges against you and you will plead not guilty.
Lo que eso quiere decir es que yo le voy a explicar todas las acusaciones en contra suyo y usted se va a declarar no culpable.
All right. Long day, hold on. All right. All right, Mr. Joel Alvarez Romero, in case 22 CR 007424H, you've been charged with the charges I previously listed.
Ok, señor Joel Álvarez Romero, en el caso 22 CR 007424H, usted ha sido acusado con las acusaciones y cargos presentados que ya le dije, que ya le enlisté y le dije.
Ms. McLean, you did waive formal reading, correct?
Correct.
Su abogado, el señor McLean, ha renunciado a que se lea formalmente cada acusación.
All right, Mr. Alvarez Romero, your case has been formally accused by the Solicitor General. And this case at this time will be reset for trial before a state court judge.
Señor Joel Álvarez Romero, su caso ha sido ya presentado y en este momento lo que voy a hacer es referirlo para un juicio, para que se le ponga en el calendario de un juicio con un juez estatal.
At that trial, you'll have a right to an attorney just as you had today.
En ese juicio, durante ese juicio, usted tiene el derecho a un abogado de la misma forma que lo tiene en este momento.
You do not have the burden to prove those charges at trial. The state represented by the Solicitor General bears that burden.
Usted no tiene que comprobar nada, no tiene la responsabilidad de comprobar nada. La Fiscalía y el Estado que ha puesto los cargos en contra suyo son los que tienen la responsabilidad de comprobar y probar esas acusaciones.
And you will have to convince the jury beyond a reasonable doubt. Oh, I'm sorry, the state will have to convince the jury beyond a reasonable doubt in order to get that conviction.
El Estado, la Fiscalía, deberá comprobar más allá de una duda razonable en frente al jurado para que ellos, o sea, esa es la carga que tiene el Estado.
If they do get conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000.
Si es que lo encuentran culpable, le pueden sentenciar a un máximo de 1 año en prisión o $1,000 de multa.
If they do get that conviction, you could face a fine of $1,000 or it's a 1 year in prison. Based upon this information, how do you plead?
Como le digo, si es que se le encuentra un jurado culpable, le pueden dar una sentencia de hasta 1 año en la cárcel o $1,000 en multa. Conociendo esta información, ¿cómo se declara usted?
No culpable.
Not
How do you-
guilty.
Oh, I accept your not guilty plea. Your case will be reset to a state court judge at this time.
Acepto en este momento que usted se declare no culpable y estoy refiriendo su caso a un juez estatal para otro calendario en otra ocasión.
Gracias.
All right. Is there anything further, Mr. McLean or Ms. Salette?
Nothing further.
Nothing from the state, Your Honor.
All right, best of luck to you, sir.
If that is all the court's business, Your Honor, for me, I may be excused.
You may, wait, well, hold 1 second before you go. Is Mr. Howard on the screen? I want to make sure your services are not required for anybody on the competency calendar. Oh, he's in the breakout room. Let me go and hold 1 second, Ms. Lucia, let me check and then I'll come right back.
Yes, Your Honor, I'm right here.
Just about to get excused, we'll get some lunch.
Hey, Judge. We also have he's completed, right? Okay, we also have the competency for position 10, Mr. Johnson in here.
All right, I'll go into the breakout. We'll start the competency calendar now. Ms. Lucia, you are free to go. Take care. Have a great rest of your afternoon.
And Judge, I believe that's the completion of the state all-purpose calendar.
Only those who need to remain for state all purpose, all those who need to remain for competency, please do so. Everyone else can be excused and go to lunch. Take care.
Thank you, Your Honor.
All right,
Have a
I'm
good
gonna
day.
go into the breakout room and start the competency calendar. Take care, everyone.
Could Ms. Champion call 22392 for just a second?
I'm gonna go.
Because otherwise.
Oh, yes.
If she really needs them that fast, I'll go into her office.
He's done.
Then the champion's at 100 Beach Street?
No, she's at,
Oh, the courthouse, okay.
I'll just park in the deck, which will already take up the parking.
And then go.
And I'll
Drop 'em
walk
off.
over.
Yeah. Want to go get those stored. But if you need people from here, I'm gonna submit them out.
Yeah,
So if you need me to do anything else, let me know.
okay. I think everything was pretty smooth, even Mr. Plant's case.
Huh?
Although Mr. Plant was not able to. It did. He's done it. He's done everything 24 hours.
Francois,
Yes, I do. Yeah, absolutely.
Yes,
do they still need the ones off the 3 North?
is that the one, that's the one that you went to 3 North, right?
Yeah.
Yeah, they do, cause Ms. Herb went with Derek Howard to go get him interviewed, or he went to talk with him.
So he coming up here?
Huh? Okay, come here, Herb.
Oh.
Derek Howard, he's coming up here.
He's gonna actually be on his phone, he's not gonna come up there, he's gonna be through the Zoom, but you know which ones he spoke to? Ms. Herb went to 3 North with Derek Howard.
The one at 312?
Oh, he's not gonna be able to probably come down. Even our rate.
Yes.
And 307. I just know their room numbers. I don't remember their actual names. I'm sorry. You heard me?
You hear me? We got you one. You ain't got.
I can't hear you. You're breaking up.
Got you one.
You got me one.
I'm good for, I'm gonna come out in about 5 minutes. I'm gonna try to reach April.
No?
I'm gonna try to reach April.
April?
Yeah.
I can't hear him.
You know, it's called makeup.
I don't know who's April.
April champion the party.
Oh, I don't know. He's breaking up. I can barely hear.
Yeah, hey, McDuffie. That's him. Right?
Yeah,
Yeah, okay, what's,
What'd you say, McDuffie?
I'm just trying to see if they need these people up here. We have position 17,
Let me see.
Mr. Rose,
let me get the full sheet. Where is the full sheet? Hold on, let me get the full sheet, hold
Is
on.
it Rose Winston? That's his name?
and position 3, Mr. Clark.
Yeah, Mr. Clark. Mr. Clark.
We can't, have him out here so long.
Okay, so okay.
I've been up here almost 30 minutes now.
Morris, come here.
We talked to Clark. We talked to us two people.
McDuffie's trying to figure out.
I'll check for you real quick.
Derek Howard went with her.
We don't need him. I can put him back. Yeah. Oh, shoot.
Hey, Duffy. Duffy.
Yeah.
From what Howard told me, he's gonna need Julio Ruiz. And he's on four spot.
Just him?
Travis Clark, I don't know what happened with that. He went upstairs to talk to him. And he's on 3 North. And he said, also said maybe Weston Rose.
I have him out in 700 now. He been out almost 30 minutes now. I'm just trying to make sure that
those are the only 3 that he gave me.
All right, can you do that? Unless y'all just call Derek, you got Derek's number, just call him.
And we got David Johnson here for him.
Call Derek, so we know which guys.
You got that, Duffy?
yes.
All right.
I got Clark. Then I had to go to 4 North and get the other one.
4 South.
4 South, whatever.
Yeah.
Hey, hello?
Okay, well, can I go first? When they start?
Hey, Duffy, they usually do everybody's case in a breakout, and then they come back. So it doesn't go one at a time. Okay?
I hear you.
All right.
All right, courtroom 2 can be excused. We will not be speaking directly to any of the defendants who are there at the jail. I will handle the cases and they will be informed through their attorney of their reset dates, all right?
Thank you, Your Honor.
All right, and also the same, will you tell me who was at jail court's iPhone?
That's,
Position 10,
Officer Duffy.
Position 17,
position
Pos-
17, okay, that, Mr. Howard.
3,
I'm sorry, go ahead.
position 3, and position 18.
All right, Mr. Howard will come by and speak with each of them at some point and let them know their reset dates. I'm gonna excuse you all so that you all can continue with other business, all right?
Yes, ma'am. Thank
Both of
you.
you all are excused. Thank you.
Thank you, Your Honor.
Bring back in that gentleman's brother.
Hello, Mr. Jordan.
Yes.
Should
Ms.
I still
Jackson?
should I still be on hold?
No, I think, so she told the sheriff deputies that they could take all the inmates back. So I don't think they're gonna have anything that needs to be reported, so there shouldn't be any bond hearings or anything else going forward. They're just going over all the competency cases now.
Okay, I just want to, sure. So I should go ahead and disconnect?
Yes, you can disconnect. Yeah, she was saying everybody could disconnect unless they needed to stay for the competency counter, but you don't have to stay for the competency counter.
Okay, all right. Well, thank you.
You're welcome. Have a good one. Thank you.
You too.
We are gonna wrap up this calendar as Ms. Champion will review the competency calendar for us, and then we will be in recess until next week. Ms. Champion, will you very quickly review these on the record for me?
Position number one, reset SAP competency calendar 12A. Position number two is gonna be reset competency 1215. Position number three, reset competency 126. Position number 4 and 5, reset competency 2. Position number 6 is reset competency 1215. Position number 7 is reset competency 15. Position number 8 is reset competency 12.8. Position number 9 is reset competency 12.15. Position number 10 is 10 and 11 is going to be reset competency. Reset SAP 12.8. Position number 12 is reset competency 12.8. Position number 13 is reset competency 15. Position number 14 is reset competency 126. Position number 15 is reset competency 1215. Position number 16 and 17 is going to be reset competency 1215. Position number 18 is reset competency 1215. Position number 19 will be non-cross. And position number 20 is going to be a new bond order submitted. It's going to be reset for the notes.
And Ms. Crawford, position 11, are you going to submit a non-pros for that today? So Ms. Champion, if you'll notate that position 11 is going to be a non-pros, that FTA.
Oh, yeah, the FTAs are, no.
It's going to be non-cross today or on the SAP.
Oh, that's a good question. Will you
Today,
not
preferably.
Today, Ms. Crawford? You're muted.
Yes, I will absolutely null process today. There's no need to take up space and time.
All right. Wonderful. All right, we will be in recess until Tuesday's AP calendar. And everyone take care if I don't see you.
Okay, you as well, Judge. Thank you.
All right, bye-bye.
Bye.
Bye-bye.